Item number 1.
Please, Your Lordship. Yes. In item number 1, we filed our affidavit, Lordship. It's for rejoinder.
Where's the petitioner?
Lordship,
yes, Mr. Saha, where's the rejoinder?
Item number 1.
Where's the rejoinder?
Lordship, kindly 3 weeks time may be granted, Lordships. I will file my rejoinder, Lordships.
We'll give you 2 weeks further time. Yes, Ms. S.K. Saha, please for 2 weeks time for rejoinder, yes. Kindly file it, yes.
2. Lordship, in item number 2, I'm praying for some more time to file our affidavit.
2.
Lordship.
Why one you file, one you not file?
Lordship, in item number 2, we've recently received instructions.
Okay. MS Emrichang submits the instructions that just been received. She prays that she allowed 2 weeks time to file affidavit.
Lordship.
Prays allowed, yes. This up to 2 weeks.
Highly approved.
Yes.
Hearing 3.
Highly approved.
My Lord has heard us number of occasions, my Lord. I'll try to shorten the... Yes, give a short reply.
Reply to whom? Who's for the...
Yeah, Mr. Paul and the AG has made their submission already.
See, you drag on so long, we don't forget what submission is.
Exactly.
It's regarding that whether it should be pleased for the council.
Madam.
Wait to that correction.
No, it is a send of the governor, my Lord. Yeah, what they have done is that, my Lord, the bill was referred to the governor. Governor returned the bill with the comments. Now, under the rules, regulation, it has to be placed before the floor of the House, Council. Now, the bill was never placed before the House of the Council. Only the Executive Committee has modified the bills, forwarded to the governor again, governor given the assent. That was the case I had.
What was Mr. Paul's reply last time?
Paul's reply yesterday, last occasion, that no, the message sent from the government was not the message of the governor. It was only a internal communication between the law department.
That's the only point.
Yes, that I'll point out.
One was that the first issue was, Millets, that I had submitted before your Lordships, that Millets, it's not a message of the governor. It was simply returned from the Secretariat, from the Department of District Council Affairs, Department of the Governor of Meghalaya. That's one. The second aspect is, Millets, be that as it may, it has finally obtained, the assent of the governor was given to this bill. Now the question therefore arises, Millets, and I had posed it before myself, that whether my lords would go into the legislative arena of Millets' body, which otherwise is vested with the power to Millets make laws. In other words, Millets 212. That's one aspect your Lordships would have to look into. And the third thing, Millets, I had submitted before your Lordships is that if my learned friend is challenging, Millets, it to be ultra-virus of a certain provision, mere defect in Millet's passing of a bill, as long as Millet's the power of passing the bill is there, and Millet's has attained the assent of the governor, it has become into a law, that by virtue, per se, Millet's would not render it ultra-virus. It would have to be ultra-virus a provision of the Constitution, or any other law for the timing in force. Yeah, that Millet's has not been demonstrated.
Well, the last occasion, first day of hearing, I have a place in number of decisions.
Subject to what my friend says, Millet's.
Well, this is difficult to argue. I concluded my argument. They are supposed to give a response. They never give a response. In a piecemeal response they give. Now I reopen again in that case, madam. I have a
reopen again.
Reopening the argument, madam.
Okay.
So submitting the authorities, madam. My learned friend that what happened before, after the bill given the assent and the law bill become a law, thereafter I can challenge it. But what was transpired before the bill reached into the stage of a law, one cannot challenge. But I have authorities. Supreme Court made it very clear that two parts are there: substantive procedure, substantive law, and the procedural one. Now the substantive one is with regard to the competency of the lawmakers, my lord. So that is one aspect of the matter. Procedural law, my lord, the process for enacting a law, that is also judicial review is meditable. What the Constitution says, my lord, what is transpired on the floor of the House, court cannot enter in that on the floor of the House. That is a prerogative of the Speaker. But the procedure for enacting the law, the procedure provided by the Constitution or the law.
Judicial review.
That is judicial review. I'll place that judgment also. Before I place that judgment, my lord, they have brought on record in the affidavit, my lord.
But
They,
you see, one thing, Mr. Changre, so is that
well,
what Mr. Paul is arguing is that there's no defect as such. It will not amount to a bill being returned by the governor, which will necessarily, after amendments are made, have to be placed for the House again. It's just a manner of a routine kind of pointing out that some changes which was done at the level of the Executive Committee and sent back. So that is the only thing. Whether in the District Council this legislative process can, this can be allowed, or can be understood in that manner, that the send back is not a message from the governor. Yes, I addressed that point also.
yes. But there is not the bleeding in the affidavit filed by both the parties.
No, but then if
I'll come to that one.
Law,
Yes.
you can look to it. Whether procedure is, that the procedure has been defeated, or whether what has done the council with regard to, correcting that part and
Yes.
without placing it before the House and sending it back to the governor for assent, whether that will suffice.
Yeah, my lord.
To make the
That
law,
also,
yes.
my lord. That also, Lordship has correctly pointed out. In that count also, the law itself is bad. Because here, the floor of the council is the authority and governor is the ascending authority. Now, the executive committee has no role to play. Law department has no role to play. But it comes to making a law. My lord. Now, I'll just show, my lord, the page number 27 of the...
Try and make your arguments brief. Yes.
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 27 of the writ petition, my lord. Page 27 in the writ petition. This was the bill passed by the council.
27.
27, my lord. On 27 July 2019. Now, nature of the bill may I introduce, my lord. Number 2, my lord, what they are trying to introduce amendment, my lord. Number 2, in the Khasi Hills Sonora District Council nomination election of same deputy CM and electors of Hima Maram, Sansach, here in Sansach, in section 1, after subsection 2, the following proviso shall be inserted, namely, this one, provided the rights shall compare, the act shall apply in matter relating to village administration only and not on land regulation. So this is the introduced by the floor. Well, second was in the principal act section such, the following proviso shall be inserted, namely, provided in rights shall compare, the Mantri shall be known as Rangpa Shanong headman. And the third one is the next page. In the Principal Act Section 8, after subsection 3, the following proviso shall be inserted, namely, provided in rights of somewhere where a vacancy of the post of Mantri or headman occur, it shall be reported the same and his darbar with a recommendation from the darbar right, and the meeting for election shall be presided by the CM or by any person authorized by him in the presence of the representative of the darbar right, who will jointly declare the election result. Further, the term of office of the Mantri or headman is fixed for a period of 3 years from the date of issuing the Sanat. With regard to the second two provisos, my lord, there was no amendment. Governor did not, or law department did not interfere with. What they interfere with the first proviso, my lord. Now, this was the bill. Later on, my lord, communication, my lord. May I just come to page number 40. Well, 37, my lord, is 37 also. This communication given by the law department. 37, writ petition. Addressed to the secretary. It says that I am directed to refer to your letter on the subject cited above and to state that Kasil Sons and Sons Such Maram Bill 2019 has not been assented to by the governor. It says the contents of letter Sons and Sons Such, along with the enclosures forwarded to you, white letter Sons and Sons Such, may also kindly be taken into consideration. Further, the agreement Sons and Sons Such. So this is one of the communication given by the law department to the council after they received the bill from the council.
Yes.
And page number 38. This is also one of the observations given by the government. This they are doing on behalf of the governor. I'm directed to refer to your letter to the subject cited above and to say that such amendment bill 2019 has been examined. The words land regulation as would appear in the proviso of the subsection 1(2) of the Principal Act proposed in the amendment bill, provided the rights of some pair, the Act shall apply in matter relating to village administration only and not on land regulation, may kindly be clarified or given clear definition. So this is the matter.
Communication.
Yes. Then 39 also. Then I'll straight come to page 40. This is crucial. Page number 40. After council has given reply, now the government say this one, my lord. It says, my lord, with reference to subject cited on the subject cited above, I'm directed to refer to say that the Law Department of the Government of Meghalaya, after a careful examination of the bill, has amended the following, made the following observations. The proviso at clause 2 of the bill may be omitted, as the Principal Act has been enacted only to provide the procedure for nomination and election of CM, Deputy CM and electors of Himam Maram, and so to look after the day-to-day administration of the village and not for land administration. So the clause 1 they propose for complete deletion. The bill passed by the floor of the House.
Yes.
Yes. But these are, and you are requested to kindly consider amendment of the above clauses and resubmit the bill hereafter. The bill is hereby returned. So the bill is returned. It is not the governor did not sign. We have no one dispute, but the bill was returned. So there, the submission advanced by learned colleague that it was an internal communication between the two is absolutely not supported by the record. But this happened. Responding to this, what the council has done, I don't kindly see the affidavit filed by the council on 29 August 2025. They brought on record pursuant to lordship direction. Short affidavit filed by my colleague.
29 August.
2908, yes, August 2025.
You don't have a type to go.
Yes. And page number 4.
Yes.
My learned friend produced a single paper lordship directed him to place on record true affidavit. So he filed it. Now what it says, this is in response to the page 20 of the writ petition we read out. Now it says, my lord, 1st September, addressed to my lord. Now reference this year dated 28 August 2013, that is which we read out in page number 20 or 40 of the writ petition. It says, my lord, with reference to your letter on the subject cited above, I am directed to inform you that the Executive Committee KJTC has agreed and considered the observation made by the Law Department of the Government of Meghalaya as provided under sub-rule 1I of Rule 92 of the Assam and Meghalaya Autonomous District Constitution and of District Council's Rules 951 as amended. Same has been incorporated in the above mentioned bill accordingly. Therefore, the authenticated copy of the bill is hereby resubmitted for favor of your kind information and further necessary action on your end. Now here, Lordship kindly see Rule 92 of the Council Rule. It's very clear. Instead of placing the bill before the House, my lord, this executive committee has done this, and now they refer to Rule 92. My lord, can you see? But it's me, my lord. Formal revision of bill, it says, and submission of it to the chairman for authentication. My lord, when a bill has been passed by the district council, the secretary shall, if necessary, renumber the clauses, revise and complete the marginal notes thereof, and make such purely formal consequential amendments therein as may be required, and a copy of the bill shall be submitted to the chairman and shall be signed by him. But this is the clerical work the secretary can do. It is not the doing away with the amendment clause. Now, when you read down, my lord, to number 2, after the bill, the entire procedure is stated. What is the procedure to be followed when the bill is done? After the bill has been signed by the chairman, the secretary shall send an authenticated copy to each of the following to the Executive Committee for information, to the Governor for information through Secretary, District Council Affairs Department, Governor of Meghalaya, if the bill does not require the approval of the Governor, being not so specified in any of the provision of the 6th schedule, or to the Governor for approval thereof if it is required under any provision in the 6th schedule of the Constitution of India. 93, my lord, is important. My case is here, my lord. When a bill which has been passed is submitted as in rule such and such, and is returned by the Governor with a message to the District Council for reconsideration, the point or the points referred for reconsideration or amendments recommended shall be put before the Council by the Chairman and shall be discussed and voted upon in the same manner as amendment to the bill, and it shall be presented again to the Governor for his assent. So therefore, the bill returned by the Governor has to be placed for the Council, the floor of the House, which they have not done it. Therefore, this is absolutely in contrary to the, my lord, the scheme of the 6th schedule. And with regard to the issue raised by my friend, that the judicial review will not lie in the present nature is absolutely incorrect. My lord, I've relied, my lord, 7 judges, seven decisions, my lord, which submitted.
Yes, let's see.
Yes, my lord. First is 1961. AC, my lord. Page number 232.
So you mean to say that changing from land regulation to the word land administration needs debate in the House?
Exactly, madam. That is
So 92, even the last part of 92 and even 90 proposes that suppose a bill is returned and some amendments have been suggested.
Right.
Of some reasons the bill has not been signed. What those necessary amendments were suggested.
Yes.
That has to be debated again.
My lord, that is a theme of the bill earlier introduced by the floor of the House. So if that such nature of recommendation comes from the government or the Governor, but it requires deliberation by the elected body. It is not the duty of the executive.
Ask me, you have a copy of it?
But these are paper.
Yes.
My lord.
Famous case, Adhabariti.
Yes, this is a very famous case, my lord. May just take the relevant paragraph. My lord, we come to page, paragraph, my lord. 52. Wait, 52 and 79. My lord, here in the Assam case, it requires a prior assent of the President for passing the bill, enacting the law. So prior assent of the bill was not obtained from the President of India. And therefore the Supreme Court.
Para 52.
Para 52, my lord. May I read, my lord. Incidentally, we may observe that the differences in the provisions.
Which page reading?
Paragraph 52.
Page of the CIF.
My lord, I'm carrying the printed copy, my lord.
We do not think it necessary.
Paragraph 52, my lord.
How does it start?
It starts, my lord, incidentally, we may observe.
No, it doesn't match. That is para 53.
I think my friend is
but
reading from SSC online to print, my lords. That's why the paragraphs will be little.
But just, I'll come to that.
Until you give a uniform citation so we can follow.
Right. But I'll just bear with me regarding this one. I'll come to the another judgment.
No, you can't read SEC online if you're placing AIR.
But for the time being, let me skip this one, my lord. I'll place it in the proper document. I'll come to the second judgment, my lord. I'll come to the second judgment. But Holon case, my lord. Equal to Holon case, my lord. 1992, supplementary to ACC, page number 651. Relevant para, my lord, maybe 63, 65, and 186. May take to para 63, my lord, first.
This case, no.
63 and 65.
Or not, you log out from your device.
Merit. The criterion for determining the validity of a law is the competence of the lawmaking authority. The competence of the lawmaking authority would depend on the ambit of the legislative power and the limitations imposed thereon, as also the limitations on mode of exercise of the power. Though the amending power in Constitution is in the nature of a constituent power and differs in content from the legislative power, the limitations imposed on the constituent power may be substantive as well as procedural. Substantive limitations are those which restrict the field of this exercise of the amending power and exclude some areas from its ambit. Procedural limitations are those which impose restrictions with regard to the mode of exercise of the amending power. Both these limitations, however, touch and affect the constituent power itself, disregard of which invalidate its exercise. 65 may come to. Although there is no specific enumerated substantive limitation on the power in Article 368, but as arising from very limitation in the word amend, substantive limitation is inherent on the amending power, so that the amending does not alter the basic structure or destroy the basic features of the Constitution. The amending power under Article 368 is subject to the substantive limitation in that the basic structure cannot be altered or the basic features of the Constitution destroyed. The limitation requiring a special majority is important, relevant to my case, is a procedural one. Both these limitations impose a feather on the competence of the Parliament to amend the Constitution, and any amendment made in disregard of this limitation would go beyond the amending power. We come to last, my lord, page para 186.
Yes.
My lord. 186. My lord. We have reached the conclusion in paragraph 7 of the 10th schedule is unconstitutional, that the entire 10th schedule is constitutionally invalid in the absence of prior ratification in accordance with the proviso to clause 2 of Article 368. That the doctrine of severability does not apply in the present case of a constitutional amendment which suffer from the fact of absence of ratification as required by the proviso to clause 2 of Article 362. That the remaining part of 10th schedule reminders and such is also unconstitutional for violation of the basic features of the may not come down to safe lordship time. So here there was no ratifications. So ratifications because it is a procedural matter.
So you say that no ratification?
No ratification, therefore.
By the?
Yes, the Supreme Court struck down that 10th schedule amendment. Okay. That is one case. Second case, my lord, may take to NGSC case, my lord, I'll come 2016, volume 5 SEC, my lord, page number 1, relevant para, my lord, 856, 857, and 862. Yes. That relevant paragraph is, my lord, availing from running page number 646, 43, 643. Running page 643.
Where they refer to last judgment.
My lord. Yes. Paragraph 856. This view was taken forward in Ikoto Holohon case paragraph sunset, where it was held that procedure for enacting a law should be followed. Although it is not expressly stated, but it appears that if the procedure is not followed, then the law to that extent will have no effect. In this regard, it was held at paragraph sunset of 10 statutes, and it was quoted, my lord. May come to 857. Strictly speaking, therefore, an amendment to the Constitution can be challenged only if it alters the basic structure of the Constitution, and a law can be challenged if, may come to 4, it is enacted without following the procedure laid down in the Constitution. The lawmaking procedure has been laid down in the Constitution. Same thing for the 6th schedule. It is laid down. It is not a mere directory. May I come to page para, my lord? Then para
862.
Yes, 862, my lord. In such and such case, the question of the extent of judicial review of parliamentary matters came up for consideration. Speaking for such and such himself, it was held by such and such with reference to such and such that procedural irregularities in Parliament cannot undo or vitiate what happens within its four walls, that is, internal parliamentary proceedings. However, proceedings that are substantively illegal or unconstitutional, as opposed to irregular, are not protected from judicial review.
So, where's the distinction? Is this the action by them
my lord,
totally substantively illegal?
Yes, my lord.
And unconstitutional?
Yes, my lord. But what, according to me, what is transpired on the floor of the House is the domain of the House only. Right. But here the procedure, my lord.
Whether it can be termed as a slight irregularity in the way it is processed.
It is a substantive violation, my lord, of the lawmaking procedures.
Because there's a distinction.
Yes.
If it's just irregular, then it's judicial review will not come. But
exactly.
Substantively, which if it alters the the basic structure, premise or basic structure. Or,
yes.
Then a judicial review will come in.
Right. But here, my lord, it is not irregularities. My lord, here the message sent by the governor is never placed before the House. The stranger has taken over the role of the lawmaking authority. So it cannot be irregularities.
You want to say that it's a usurpation?
It is usurpation by the executive, my lord. And if I accept the condition by my learned colleague, that is the role of the governor was issued by the law department. So it is not a mere irregularities, but it is a substantive violation of the procedural law, lawmaking procedural law, my lord.
Okay,
my lord.
Yes.
That para 863 also more clearer, my lord. It says, insofar as the NGAC Act is concerned, nothing has been shown by any substantive illegality in its passage or anything unconstitutional in its passage, in the sense that any provision of the Constitution or any substantive rule regulating parliamentary activity has been violated. At best, it can be argued that procedure there was a violation, but our attention was drawn to the rules of procedure and the decision taken in accordance with the rules which indicate that there was no procedural violation in the introduction of such. So Supreme Court said procedural irregularities is not there in JC case, my lord. But in my case, my lord, is absolutely a substantive violation of the mandatory provision of law. Next judgment, my lord, may come to 2013. 1 ACC, page number, my lord, 745, relevant paragraph 8. Is the application by the legislature and usurping by the governor.
Which one?
Relevant paragraph 11.
Overruled. Okay, your judgment is overruled.
That is.
You see, para 8.
Okay. My para 11, madam.
Just come down.
Madam, I will not place. My colleague said it is overruled, so I will not emphasize on this for the time being.
For the time being, it's showing overruled.
Oh, madam, I'll escape for the time being.
I thought I should just inform my friend.
Madam, it's okay.
Decision bench. I mean, two judge bench.
I'll come to in that case another case, madam. Two more. 1987 1 ACC. Page number 378. Relevant paragraph 8 and 9. Paragraph 8, madam. Also the law is struck down. Para 8, madam.
The governor's case.
Yes.
Madam, Shri Sanjay Sinha, appearing on behalf of the state of Bihar, urged that the court is not entitled to examine whether the condition precedent for the exercise of the power of governor under Article such existed or not, for the purpose of determining the validity of an ordinance, and in support of this proposition, he strongly relied upon the decision reported in such case. We do not see how these decisions could possibly help in the present case. They do not at all deal with the question which we are called upon to decide here. It is true that according to the decisions of the Privy Council and this court, the court cannot examine the question of satisfaction of the governor in issuing an ordinance. But the question in the present case does not raise any controversy in regard to the satisfaction of the governor. The only question is whether the governor has power to repromulgate the same ordinance successively without bringing it before the legislature. That clearly the governor cannot do. He cannot assume legislative function in excess of the strictly defined limits set out in Constitution, because otherwise he would be usurping a function which does not belong to him. It is significant to note that as so far as the President of India is concerned, though he has the same power of issuing an ordinance under sunset as the governor under sunset, there is not a single instant in which the President has, since 1950 till today, repromulgated any ordinance after its expiry. The startling facts which we have narrated above clearly show that the executive in Bihar has almost taken over the role of the legislature in making laws, not for a limited period, but for many years together in disregard to the constitutional limitation. I will not go down. It's extremely applicable. Here the Executive Committee of Council has taken over the role of the floor of the House, lawmakers, removing that first proviso.
No, this judgment very because it is Dr. Wadhwa. He written a book on repromulgation of ordinances of fraud under the Constitution, and I think in this case, where the entire book was annexed as an annexure when it was filed, like that. Repromulgation of ordinances, yes.
Yes, my lord.
Yes.
My lord, travel to another judgment, my lord, 2002, volume 8. 2002 volume 8 ACC, page number
Volume 8.
Yes, madam. Page number 182. Relevant paragraph would be 29. Para 29. We further make it clear that the granting of SN under Articles and such is not exercise of legislative power of the President, such as contemplated under Article 1 to 3, but is part of the legislative procedure. Whether procedure prescribed by the Constitution before enacting the law is followed or not can always be looked into by the court.
Okay.
In the last judgment, my lord, the Madras Bill matter, LPs 2025, volume 8.
Which matter?
My lord, that SN of the governor would help, the bill would help by the Madras governor, my lord. In
Oh,
that
that
case,
is-
state of Tamil Nadu, yes.
Yes, yes.
1925, sorry, 2025,
Yes, yes.
2025, volume 8, ACC, page 1. Relevant paragraph, my lord, 378 and 381. Well, we start at 378. It is running page number 224. I've seen that one. That opinion given by the Supreme Court.
Yeah.
Not pointing to any authority, but this issue was not touched.
Yes, page 1.
This issue was not taken away by the reference bench.
You're referring to para 378.
Yes, the para 378 and 381.
Justice Party wala judgment.
Wait,
Yes.
madam. The majority opinion of the court in such case held that legislative procedure to be followed before the enactment of a legislation would always be amenable to judicial review, and thus it would be open to the courts to examine the reference which is made by the state government to the president seeking his assent. Applying the same logic, it could be said that the reservation of appeals by the governor for the consideration of the president is also part of the legislative procedure, and thus the court would not be precluded from examining such reference to determine its legality and its constitutional veracity. 381. As described in such case, the role of the president under Article Sunset is a sui generis one, tailor-made to fit the quasi-federal constitutional scheme. The role of the governor in reserving the appeals for the consideration of the president is also intrinsically linked with this constitutional role of the president. It was also observed that the grant of assent is considered a legislative act only for a limited purpose, that without it, appeal cannot become a law, and also for extending immunity to certain formalities to be followed within the legislature. This immunity does not extend to other aspects of the legal procedure which follow beyond the ambit of these limited formalities. Thus, compliance with the prescribed legislative procedure leading up to assent is open to judiciary scrutiny in appropriate cases. Further, as we have discussed in the present paragraphs, the reservation of appeals for the consideration of president by the governor is warranted only in certain limited situations. So it is also very clear according to me. The Madras case was appeal.
Review aspect.
Yes, and the last judgment by side, my lord.
You said 5 judgments, now you're touching 1, 2, 3, 4, 5, 6, 7.
Yes.
The 8th judgment.
Yes. If I touch that judgments, my lord. So my humble submission, my lord. My humble submission
8th judgment, which one?
What?
8th judgment?
But other judgment, lordship, the first judgment, since the shortage of a proper compilation of the books, my lord. That 1960 is a very, very famous case that one was.
Yeah, Atibariti is a very famous case.
Okay, my lord. I just refer that the judgments, the 1960 Assam Adyapari case.
That will be para 53 in the AR.
My lord.
Yes.
Yes, my lord. May I just cite again that 1960? Yeah, my lord. Paragraph 53.
53, no?
Yeah, 53.
Yes.
My lord. Incidentally, we may observe that the difference in the provisions contained in Article 302 and Article 304p would primarily seem to suggest that where Parliament exercises its power under such and passes a law imposing restriction on the freedom of trade in the public interest, whether or not the given law is in the public interest may not be justiciable. And in that sense, Parliament is given the sole power to decide what restriction can be imposed in public interest as authorized by Article 302. On the other hand, Article 304p requires not only that the law should be in public interest and should also receive the previous sanction of the President, but that the restriction imposed by it should also be reasonable. Prima facie, the requirement of public interest can be said to be not justifiable and may be deemed to be satisfied by the sanction of President. But whether or not the restriction imposed are reasonable would be justiciable, and in that sense, law passed by the state legislature may on occasion have to face judicial scrutiny. However, this point does not fall to consider in the present proceedings, and we wish to express no definite opinion. But I come to the last parameters where the court has struck down the Assam legislation. Well, that would be para 79. There was a president sanction was not obtained by the Assam legislature. Para 79.
Yes.
Well, 79. As observed herein before, the previous sanction of the President was not obtained to the moving of the bill which was enacted as the Impeachment Act. Even though the Assam legislature had, by item such of the 7th schedule, legislative authority to impose this tax, state could not exercise this authority in the absence of the previous sanction of the president, and the invalidity of the act imposing the tax on goods and passenger is not cure. The president not having assented to the act at any time after it was passed by the state legislature. The argument that this view was seriously restricts the sovereignty of the state has, in my view, little force. Even a cursory review of our constitution provision clearly shows that primary object of the Constituent Assembly was to erect a governmental machinery with a strong central government with the object of building up a healthy economy and unifying the various component states consisting of the former British Indian provinces and the merged Indian states by subordinating local and parochial interests to the wider national interest. In any event, in adjudicating the fires of the statute, the impact of the view which the interpretation praised by the court may produce some great cherished notion of the sovereignty of the competent states must be ignored. But I will not take to other paragraph. Here also Supreme Court struck down in view of the absence of the prior president's sanction. That was in the appeal stage. So therefore, thank you.
Yes.
My lord, I will not go to the pleadings of the party. State has filed, councillors have filed. They have admitted that they received the appeal and they returned to the council, and after receiving reply from the council, assent was given.
So
it is,
General, anything to add?
yes. So it should be struck down. My lord.
Anything to add?
Yeah, Milord, one submission, Milord, which I have, Milord, which besides what I follow and adopt the submissions of Mr. Paul. Lordship will see the recent judgment of the Supreme Court in presidential reference, Milord. 2026, 1 SAC, page 1, Milord. (2026) 1 SEC page 1. I am citing this judgment, Milord, for the limited purpose, Milord, to show that there is a
Where are your assistants to provide the judgment?
Just now. This just now.
Just now? Yes,
Well, till the book comes, probably I can just respond very quickly to what my friend has said. I can't keep your lordships waiting. Well, from what I understand, what my learned friend has argued before your lordships, two issues come out. He says, Millards, that there is a violation of the set procedure which has been set out under the AD rules of 1951.
yes.
Now, Millards, the district council has, Millards, categorically maintained before my lords that this letters, Millards, which have been referred to at page 27 and till page 40, which my friend read out, Millards, I will not read it out again, are not essentially letters returning a bill by the governor with a message. Because, Millards, I think that if your lordships kindly have a look at rule 93 again. My lords have it. Well, it's when a bill which has been passed is submitted as in Rule 92(2)(3) and is returned by the governor with a message. The important phrase here is, my lords, returned by the governor with a message. Now, to demonstrate that fact, my lords, we had placed before my lords certain times when the governor had actually exercised this power and written back to the district council, my lords, with a message.
Yes.
If your lordships recollect, my lords, those letters or the message of the governor is, my lords, personally signed by the governor himself, along with, my lords, the observations that he feels needs to be incorporated into the act of the district council. It is only under such circumstances, my lords, it can be said that the bill has been returned by the governor with a message. Now, what has been placed before my lords, my lords, and I'll take your lordships very quickly through it. Well, it's at page 40.
Page 40 of the
Writ petition. Your Lordships have read it, my lords. I'll just read it again because it specifically says, with this, my lords, is addressed by whom? It is addressed by the Joint Secretary to the Government of Meghalaya, to the Secretary of the District Council, my lords. It is not from the Governor or the Secretariat of the Honorable Governor. That's number one. Now it says, my lords, with reference to the letter on the subject cited above, I am directed to say that the Law Department of the Government of Meghalaya. So these observations here, my lords, are specifically with regard to the Law Department of the Government of Meghalaya. So, my lords, it is not a case where the bill has been returned under 93. So, therefore, my lords,
It's just clarification, you mean?
absolutely, my lords. Because had it come back from the governor, my lords, then correct. Because the statute provides for a situation where a bill is passed in the house, it is forwarded to the governor, my lords, applies his mind, feels that there is something, so therefore that expression is there. Your lordships will see in other cases the expression is not there. Here it says, my lords, message from the governor. And I've demonstrated before your lordships, my lords, when this power under 93 is actually exercised by the Honorable Governor, how it is done. It is signed, and not one instance, my lords. I think we placed 3 instances before your lordships.
By affidavit.
It's not by affidavit, my lords, because it's not in connection with this case. These were records, my lords. We had made copies and placed it before your lordships. Your lordships, I have it here again. I can just place it. Well, what one we pointed out was of 2005, where the then governor was Mr. M.M. Jacob, my lords. 3, no?
The valuable land regulation administration with the division of PTA. So that's why they take out the judgment to show me that paragraph. Concerns with this one. That's what I understand. So then I'm here come in and open the paragraph for a question of legislating. Yes.
Let's power under rule 93 is exercised. Let's just for your lordships quick reference. I'll just place it.
I think, do we have copies here?
We have given copies.
That must be available here. Okay.
Para 360. You've given the list.
So see, the only thing is, from what we have seen, is that this acts primarily only for succession and appointment of the headman of this area, right? And so what happened was that this land administration had crept into the
Act,
yes, not for purpose of land regulation.
Lordship.
So what was mooted was that it should be left out totally. Correct.
It should not be land regulation.
If you come back to page 40,
where
the land regulation, where does it appear? 40, right? Yes, it's 40. It says, no, where is that? No, the earlier one, which was...
Well, it's the first, I think your lordships are referring to, Millets, this one.
27.
27 is the first.
37 minutes.
See, you just come to the proviso, correct? Provided rights of superior acts apply in matter related to village administration only and not on land regulation.
Land regulation.
So they said remove this land regulation.
Yes.
That is the message, another message, given by Law Department, that since it concerns only the appointment and election of the CM electors of Imam Maram, so that should disappear from the Act. So that's the only thing. It's not seeking an amendment per se, but just clarifying. I do not know, but subject to, yes. Let's see his message.
Well, it's at page 40, your lordships, what your lordships are referring to is proviso to so-and-so may be omitted as the principal act has been enacted only to provide procedure for nomination of so-and-so of Imam Haram and to look after the day-to-day administration of the village and not for land administration.
Yes.
1944. Well, your lordships have that messages.
Yes, yes.
Your lordships would have seen in these two cases, my lords, that there is the message of the Honorable Governor, my lords. This is first one is dated 4th of March 2005, signed by the Governor himself.
Yes.
It is under his own signature, my lords.
Yes.
And my lords, the next one your lordship would have seen 6th August 2019. It is again under his own signature.
Yes. Yes.
So my lords, I'm not reading the substance of these two
Yes.
letters, my lords. Your lordships would have seen that under what circumstances the power under 93 is exercised.
This constitutes a message in its totality.
Yes, my lords.
Yes.
So once, my lords, my learned friend cannot demonstrate that there has been, my lords, actually infringement upon some statutory provision, I think, my lords, then we are relegated back to a position that where there may have been some kind of error, my lords, in passing of the bill, but fact of the matter remains, ultimately it goes back to the governor gives his assent.
Yes.
So therefore, my lords, whether your lordships would then inquire into what happened. And my lords, I'll just place one judgment very quickly on this. Well, it's just give me the page. Yep. It's, this is 2007 3 SCC, page 184.
Page
184, my lords. This is the Raja Rampal's case, my lords.
Yes.
2007, volume 3, SCC, page 184. Relevant paragraph, my lords, is paragraph 360, which your lordships would find at page 347.
Yes.
That's, may I just read? The question of extent of judicial review in parliamentary matters has to be resolved with reference to the provisions contained in Article 1221 that corresponds to Article 212, so and so. On a plain reading of Article 1221 prohibits the validity of any proceedings in Parliament from being called into question in a court merely on the ground of irregularity of procedure. In other words, the procedural irregularities cannot be used by the court to undo or vitiate what happens within the four walls of the legislature. But then procedural irregularity stands in stark contrast to substantive illegality, which cannot be found included in the former. We are of the considered view that a specific provision with regard to check the role of the judicial organ versus vis-a-vis proceedings in the parliament uses the language which is neither vague nor ambiguous and therefore must be treated as the constitutional mandate on the subject, rendering unnecessary search for an answer elsewhere or invocation of the principles of harmonious construction. So, let's, if at all it has to be touched, it would be incumbent upon the petitioner to demonstrate before your lordships, Melits, that it falls within the category of substantive illegality. If it is substantive illegality, Melits, yes, your lordships will inquire into it. If it is merely a question of, Melits, irregularity of procedure, Constitution bench, Melits, in this case says no. The embargo of 212 would and 122 would come into play. In this case, Melits, my humble submission before your lordships is this is not a case where there has been any substantive illegality. There may have been some procedural impropriety, Melits, I would put it as that. But that, Melits, cannot render a law, Melits, being set aside by this honorable court, especially considering the fact that it has been now signed by the governor and, Melits, it has been published in the Gazette, it has become an act.
Yes.
And so far as well as the judgment placed before my lords of the 1961 Supreme Court judgment, Melits, that Assam case, that, Melits, in my humble submission would not have too much of a bearing in this case because, and it would rather fortify what I've argued before your lordships. Because in that case also what was provided for is, Melits, the prior assent of the governor, of the president was required for the state legislature to pass that law. And the penultimate paragraph which my learned friend read, the Honorable Supreme Court interfered because, Melits, it is a position, it cannot be like that I pass the law and then take it before the governor. Here was a requirement that you have to have the assent of the president. Only then you are authorized to legislate on a subject. This legislation was done without the assent. So therefore it comes within the it's four corners of substantive illegality. So that would not really assist my learned friend. It would rather support the case of the petitioners, of the respondents, saying that only in such cases of, it's absolute illegality, if I may put it so, then your lordships would then enter into the realm of deciding the legality of this particular provision and whether to set aside or not. In this case, in my humble submission, it is not there.
Yes, Mr. Arpi General.
Yes, my lord. Yes, my lord. So, my lord, the issue in my humble submission before your lordship is whether the removal of technical defect in the bill, at best it would be described as technical defect in the bill, would necessarily require to be placed before the legislative body is the issue, my lord. What your lordship is, in my humble submission, required to see that if the legislature has or the council has passed the bill with all letter and spirit, and there are some technical issues or technical defects, whether it can be cured by the executive or not, my lord. And this, in my humble submission, defects at best are technical in nature, which have been removed, and it is within the power of the executive to make the bill workable by removing the defects which are technical in nature, my lord. And for that purpose, my lord, I cite the recent judgment, because the Honorable Supreme Court in Tamil Nadu reference case issue appeared that whether in every case message has to be before the council while returning the bill. The Honorable Supreme Court devised a tool called dialogic process, my lord, that with dialogic process also, without sending the bill with the message, the parties can discuss, negotiate, and can resolve their disputes, my lord. For that purpose, my lord, kindly see this 2026 1 ACC page 1, my lord, paragraph 56. Paragraph 56, 57, my lord, 71, 159, 160, 167, and 177, my lord.
159, 160.
159, 160, 167, and 177, my lord.
Yes.
Now kindly see paragraph 56, my lord, at page 286. Even in the case of a bill, my lord, page 286, paragraph 56 at the top of the page, my lord.
Yes.
Which is not any bill, the first proviso empowers the governor from withholding the bill when it is presented again to the governor. What is impermissible to withhold through a dialogic? What is impermissible, my lord, to withhold through a dialogic process in the first proviso cannot be withheld abruptly or simpliciter by the governor alone, implying the withholds option in the substantive part. This fortifies our reasoning. Term withholds in the substantive part of Article 200 is conditioned and qualified by the first proviso. 57. We are of the opinion that if the two interpretations are possible, then an interpretation that favors a dialogic process which encourages institutional committee and deliberations between
What's the real meaning of the word dialogic?
Dialogue, my lord, because there was some
Yes.
Mr. Sangreso is placing the case before your lordship is that if there is some suggestion, some correction by the governor, it has to follow the mandate of AD rules of 93, which was cited before, AD rules of 93. The bill returned with the message to the house. Before that, there is a stage where there can be dialogue between the institutional, like the governor, executive, the district council department, that look, this is a technical defect which required to be removed. And in that context, there is no requirement to withhold or reject the bill. The governor can send the message or can point out that this is the technical defect. Please remove the technical defect and bring the bill to me, and I will do it. And this, for that purpose, a dialogue is entered into between the constitutional authorities, my lord. That is what the Honorable Supreme Court in paragraph 57 also says, my lord. We are of the firm opinion, if two interpretations are possible, then an interpretation that favors a dialogic process which encourages institutional committee and deliberation between the constitutional institutions, in this case governor and the house, must be preferred over an interpretation that limits or eschews such dialogue. Such an interpretation prevents institutional redundancy. We observe a deliberate constitutional design in incorporating governor within the definition of legislation in Article 168. Institution of governor and the house are coupled together in process under Article 201. One institution send a message, suggestions, initiating this dialogic process and the other deliberations upon this message. We find this dialogic process in consonance with the functional role assigned to both institutions. Now kindly see paragraph 105 below. Page 306, my lord. We have already held that dialogic process either contemplated under Article 200 or Act of Refer under 20 are both parts of federal scheme of constitution and also part of system of check and balance. In view of the matter, the conferral of discretion on the governor is not bound by the aid and to reserve the matter for consideration or return to legislature is no way antithetical. My lord, if you also would recall that under Article 200, my lord, and similar to what situation we have, is that if the bill is presented to the governor, my lord, governor has three options. Either he will give assent to the bill, he will reserve the same for the consideration by the president, my lord, and he will send the bill with the message to the assembly, my lord. The fourth option which has been defined, my lord, that rather than sending message to the assembly, my lord, if the issues can be ironed out or creases can be ironed out before that, that process can also be adopted by dialogic process, by dialogue between the institutional authorities. And this judgment is aptly applicable in my case, my lord. Now on judicial review, my lord, this judgment is also important, paragraph 159 and 160. In fact, learned senior advocate for the petitioner, my lord, Mr. Sangreso, has cited Kasser, and if you will see page 157, my lord.
Para 157, yes.
On 157, Kasser-e-Hind was cited. The decision in Kasser-e-Hind holds that president must be informed of grounds on which governor is reserving the bill for his consideration on issue of repugnancy. It further comes to a definite conclusion in para 25 and 27, and this was not to mean that the discharge of power of president under 201 is justiciable. Ratio in this case has been turned on its head in the state of Tamil Nadu to arrive at its conclusion. We are of the considered opinion that the state of Tamil Nadu, which was cited by my learned friend Milord, was not bound by these earlier decisions, and discharge of function by the governor or president under Article 200-201 respectively is thus non-justiciable. Beyond judicial precedent, as well as we are unable to endorse the view advanced in the state of Tamil Nadu in light of the opinion that we have tendered in the other questions above, since governor cannot withhold assent with simpliciter, only option he has are to initiate a dialogic process under 200, either returning the bill to the legislature for reconsideration or reserving it to president, who in turn under 201 may choose to return the bill with a message to legislature. The initiation of dialogic process, whether other constitutional functionaries are consulted before governor or president take a decision on whether bill must be assented to or is not a justiciable act in itself. We have emphasized that this dialogic process is part of the system of check and balance and federal system of our constitution. Nature of dialogic process contained in 200-201 is such advisory, persuasive, deliberative and mediative and consultative, my lord. So this process was followed in my case, my lord, in this present case, where the honorable governor through the Council of District Department pointed out that there is a technical and correct the technical issue and present it to the Honorable Governor, and he was assented to, my lord. So therefore, my lord, in every case, if there is some issues, discussion, deliberations without touching the substance of the bill, my lord. If the substance of the bill is getting amended, affected, certainly it should go back to the council or legislative body, my lord. So that is what I have to submit, my lord. That is a part of dialogic process, it's a part of dialogue, it's part of deliberations between the parties, and whatever and the creases have been ironed out by the parties in this process of dialogue, my lord. So therefore, there is nothing wrong. This procedural or technical objection cannot take away the will of the people, my lord. Your lordship is aware that if the amendment or the change in the bill was not acceptable, district council, your lordship, has held in one of the cases that is independent to amend the bill. The power to amend or the law is with the district council, my lord. It could have amended. So therefore, the district council all along felt that it is a technical defect which was cured, and for every technical defect, my lord, sometimes comma, full stop, the error in the spelling or the word which was intended to be used has not been used for the said purpose, my lord, it is not again represented to the assembly, my lord, or to the council or to the parliament, my lord. So therefore, in my humble submission, my learned friend in the instant repetition is raising a technical objection which has no substance. And I'm squarely covered by this recent judgment.
My lord, a short reply. Tamil Nadu case, the interaction between the Legislative Assembly and the Governor. Here is, my lord, according to the Council, interaction between the Law Department and the Executive Committee of the Council. It's distinguishable. Therefore, it is not a dialectic process, is not exactly applicable in this instant case. Second, my learned friend said that he produced the Governor message. It is not the form, but it is a substance that is important. The rule even do not say the governor should write the message and sign by him. It is a substance of the communication that can be read into, my lord. So if we go with that, it is the governor's essence. Now, assuming that there is no governor essence, governor never involved in this dialogue, in this communication, that means the law department has taken over, an executive committee has taken over, and the lawmaker of the assembly, the district council, and the governor was not involved at all. So it is absolutely illegal. Secondly, it is not technical. Removal of the land regulation, whether land regulation can be applicable in this act or not. This is substance of the bill. It is not a technical issue. Therefore, this requires the application of the wisdom of the floor in the floor of the house.
No, because the very objective of the bill is regarding regulation for nomination and election. Whether land regulation or land amnesty will come in at all. That is why that clarification was.
Yes.
That's why it's dropped.
My lordship is correct.
If you apply that doctrine that's come on, that the dialogic whatever, the first time you heard about it. Anyway,
my lord, even if,
you know,
my lord, that lordship is correct.
Whether it will not substantially change the entire, what do you call it, the structure of the act or the bill, correct? Because even in the one which is not amended, it says that it will not involve land regulation, so that it becomes onerous. You know, you don't need to include that at all to show that this act, because if the other provisions of the act deal only with the nomination election, that means that coming there is totally redundant, that term. And so if that is pointed out by the law department, that is a redundant term. You know, you clarify. So that's why they have left that out. But that, I mean, so the scope of the act, you know, remains what it is. It has not changed with the deletion of that because it says in the parent act that unamended that it will not involve, it will not extend to land regulation. Correct. And so that has been dropped. Whether that will be substantive or.
My lord, that is the nature of the bill, my lord. That was pointed out by the law department. It requires the deliberation of the house.
So whether it would require, because it does not amount to really returning the bill per se by the government. That's unacceptable because it infringes upon the constitutional provisions or repugnant, you know, to certain article. It's not that.
Inclusion of land regulation was authored by the lawmaker.
No, it says that will not include, and so by when it's written, it was totally dropped. That's all.
That's why, my lord, they recommend for dropping of the first proviso.
Process adopted by the council, we can inquire and say that, you know, with the even the act amended, it's
But-
not say it's not taking away something.
But,
It's just sort of putting it in a proper form.
but the first proviso was taken away. Totally, my lord. So therefore, my lord,
Because see, you just come back to page 27 of the petition. Right, I'm going to cut things short. See page 27.
27.
Yes. It says,
Yes.
provided that rights house impaired, the act shall apply in matters related to village administration only and not on land regulation. So,
Yes. So that
and the
will
name of the act is the Khasi Autonomous District bracket nomination and election of CM, Deputy CM, Elected Imam Haram.
well, so that first proviso, lordship, read out.
Yes,
That was recommended for dropping at page number 40.
yes. See, read 40 again.
40 again, man. So 40 number 1, the proviso at clause 2 of the bill.
Yes.
We omitted.
The proviso clause to the bill may omitted as a principal act has been
Enacted only to provide the-
the nomination election of CM and look option and not for land administration. That's it.
But this is a recommendation for dropping, madam. So according to me, whether it can be required to be dropped or not. It should come into place before
the
the
constitution the floor of the house.
I don't
But
know.
if the parent of the act itself, envisages and contemplates that will only regulate or codify the election or nomination of the CM and the CMs and the headmen of Imam Haram,
Right.
then what's necessity that is totally
My profound respect to submission is, my lord, if the bill go beyond the parent act, if the bill go travel beyond the scope of the parent act, that, my lord, excessive legislation will be removed by the floor of the house itself, not by the executive.
okay.
But
That's good.
so there's my humble
Just give you a small
submission.
One submission,
We will-
one submission, my lord. My friend has repeatedly said that it is the opinion of
Yes.
law department, my lord.
Yes.
The
No, I'm not
honorable
admitting that.
government is bound by the aid and advice of the Council of Ministers, my lord, and the honorable governor acts through the District Council Affairs Department. It is the law department. Law department is through the opinion, because, my lord, in all these matters, the honorable governor is bound by aid and advice of the Council of Ministers. This is not a discretion vested in the honorable governor, my lord. Therefore, law department or the government of Meghalaya or the cabinet advises the honorable governor, my lord. So that aspect, lordship may keep in mind when my friend is saying it is only law department.
No,
You
no,
just give
that goes
small notes.
contradictory to each other. Yes, we can submit short notes.
Within 1 week. you
What?
should give your- just under
Bullet points, Village, on what?
Yeah, just a small. Don't want elaborate.
My lord, from government side only, I have cited this judgment, and because ultimately government side may not.
So you don't need, yes, okay, fine. Yes, this after 1 week, Paris have to submit the bullet points. And we reserve it.
My lords have reserved the judgment, my lords, only for submitting.
Only for this, yes,
Yes.
we'll-
Item number 4.
Interesting point.
But important point.
Substantively does not proceed here. May proceed. Yes, yes, Mr. Bora.
Yes, may I please, Your Lordship? Lordship, I am appearing through VC, Lordship. Now, it's an appeal filed against the bank. I am appearing for the bank against the judgments dated 1/4/2024.
Yes.
Now,
May I please, Your Lordship?
Where's senior?
Lordship, as per the, if we produce the last order, Your Lordship, that the respondent were asked to file their written notes of
Where's that?
arguments.
Bora.
we have filed the written notes to,
Today, okay,
yesterday we have given a copy, we have filed it.
Okay. Then we reserve it. Is
Lordship,
subject been filed?
Lordship, actually we just received the soft copy, but I haven't received the hard copy, Your Lordship.
That we can you get it fixed with your counterpart? Yes, sir. You can conclude judgment reserve. Yes.
Lordship, I pray that we be allowed for oral.
Why? It not hasn't been hasn't been argued orally.
My senior, he wants to
Where is he?
chip.
Okay, we'll put it after 2 weeks. You
Yes,
come
Your
and
Lordship.
just for the oral arguments of the week. Yes.
Very much, Your Lordship.
Why?
It was earlier heard at
Yes.
length.
No, but just see senior here, no, whatever. Yes.
Item number 5.
Highly obliged, Your Lordship.
This also concluded, I think.
May it please your lordship. My lord, this is the closing rejoinder, so should not take too much time.
Concluded because
My lord, on the last occasion, Mr. Muzika had argued. This is that case where the service tax
Yes.
demand after 8.5 years
yeah, that is the only
by the Delhi authorities operating in
strong point. Yes.
and Meghalaya, operating in Meghalaya. So there are four points that I had raised. A, do they have a jurisdiction to operate to deal with activities in Meghalaya? National footprint versus local area. If my lord recalls, that is a jurisdiction issue. B,
But you see, Dr. Mozika argued that one thing, notwithstanding the delay, but it's in the negative list, 66B.
yes, I will
That's
satisfy.
under
Yes.
prior positive regime.
Right.
Then you have a PAN card.
Right.
You're not a government. You're
Right.
a trust.
Those are the things
Those are the things.
Right.
Then
Right. So therefore, today I have to restrict myself to 4 aspects. First is on whether I'm a government. That particular thing. He says that I'm not a government. Second is on bias. He says that is how it used to be. So therefore, investigator and the adjudicator being one and the same does not cause any problem. Third is on the local area versus national footprint, the jurisdiction aspect. And fourth is on the delay part. So, my lord, I'll start with the most important part, which is whether I'm a government or not. For a minute, my lord, if my lord comes to page 131 of my petition. Page 131, there is a table, my lord will notice.
Right.
So this table shows the period that we are
1
disputing.
second. Where's your senior?
Your Lordship, he's coming, Lordship. He's coming, Lordship.
So my lord will see that the period is involved, is 2011-12 until 2015-16.
Yes.
Now, Mr. Muzika's submission was that under the post-negative list regime,
Yes.
government has a specific definition. And I do not fit into the definition of government because, according to him, I may be state. But merely because I am state in accordance with the Supreme Court decision, I need not be a government. That was his line of argument. But before we get to that, 2 important things comes out. That negative list came into being from 1/7/2012.
Yes.
1/7/2012 is when the negative list came into being.
16 or 17?
1/7. Sorry, 1/6.
Yes.
1/6/2012. I'm so sorry. Now if my lord, that is 2017. Now if my lord takes the table, first line item 11-12 is entirely pre-negative list,
Yes.
almost 2 crore 22 lakhs.
Yes.
The second line item is partly pre-negative list, 12-13. So out of 2.63 crore, some portion. So therefore, so far as the pre-negative list is concerned, the issue of government never arises.
Yes.
If I am able to satisfy this court that during the pre-negative list regime, the jurisdictional fact is insurance company. It should be an insurance company, life insurance business. Only then am I liable to tax. I had shown, if my lord comes quickly to page 303 of my petition. Page 303, ZX.
Policy holder.
Yes, to a policy holder or a person by insurer, including a reinsurer, carrying on life insurance business. So unless I'm said to be carrying on life insurance business, the net of service tax does not come on me. I had submitted that to carry on business, I should not only be doing to the men in uniform, but also to the people at large. Clearly, I don't do that. Therefore, I was never in the business of this. This was for the welfare of the Jawans and the officers. Not only that, I had also shown, my lord, at page 301, 61, entry 61, definition of life insurance business. It takes us to the Insurance Act.
383.
Yes, and the 383 at page 400 defines what is a life insurance business,
Yes.
which means the business of affecting. It has to be business.
Yes.
And I keep saying the same thing. I was never in business. I was only protecting my men and those in the uniform. Not only that, at page 380, page 380, section 44, that the Insurance Act does not apply to certain cases, clause F,
Yes.
to any scheme in existence on the appointed day or any scheme framed after the appointed day with the approval of the central government, whereby in consideration of certain compulsory deduction made by the government from salaries of employees are part of the condition of services. So if it is a compulsory deduction as part of the salary, part of the conditions of service approved by the central government, then I don't fall under Insurance Act at all. So I can't be insurance business. And the fact that it is so comes out at page 404. Sorry, at page 382. Page 382. As far back as in 1978, my lord sees that page 382.
Yes.
This is a missive from the Government of India, Ministry of Finance. I am directed to refer to Assam Rifles Group Insurance Scheme sent by the Director, Ministry of Home Affairs in file number so-and-so, and to convey the approval of the central government under section 44F of the Life Insurance Act to the aforesaid scheme, which will cover all serving Assam Rifles cadre officers, etc., etc. So 44F covers me. Therefore, I am completely out of the Insurance Act. Being outside Insurance Act, I can't be said to be carrying on insurance business as defined. So that is one part of the story. Then my lord comes to page 404. Not only am I outside the ambit of the Insurance Act,
You exempted also.
I am also exempted under section 118 subclause C at page 404, and the exemption is at page 406. May I read, my lord? Page 406,
31st July.
31st July 1978. In exercise of powers under clause C of section 118 of the Insurance Act, the central government hereby orders that nothing contained in the said act shall apply to Assam Rifles Group Insurance. So clearly, my submission is, for the first line item and part of the second line item, i.e. the pre-negative list regime, I could never have been subject to service tax because I was not in the business of life insurance business. Not only that, for levy of service tax there has to be consideration, and a compulsory exaction through salary cannot be consideration. That was my point, my lord recalls. That's one. Now I'll talk about the post-negative list. If my lord comes to page 315,
D.
66D, what is outside the ambit of service tax is services by government. So I have to be a government. That's the long and short of it.
Yes.
If I'm a government, then I'm in the negative list, no service tax. Now what is relevant is, if my lord comes back to page 309,
To 6A.
26A.
Right.
But before 26A, my lord sees the footnote attached to that. The footnote is 96 small e in 26A. On the left hand side, my lord will see in blue 96 small e. That 96 small e, my lord will find at page 312. Lord sees that?
Inserted by Finance Act.
Inserted by Finance Act with effect from 14/5/2015.
Yes.
My lord sees that? Therefore, the submission is the definition of government, as my learned senior says, will operate only from 14/5/2015. But the negative list began from 1/6/2012.
Yes.
So if my lord now comes back to my table at page 131 of the petition,
Yes.
so in this 11/12 was positive regime, I was outside. 12/13 partly I was outside. The second part of 12/13, the whole part of 13/14 and some part of 14/15 was pre the definition of government. So the narrowed definition of government, as my learned friend had pointed out, rightly so,
If only from up to 2015-14.
for one, correct.
Yes.
Prior to that, so long as I have trappings of government, so long as there is an all-pervasive control of the government, I am government. So long as I am discharging public function, I am government. And these are all core government function, as Afgh's judgment of Supreme Court also says. So therefore, I am distilling it further to say that my learned friend's argument at best, at the highest, will be from 1/4/2015 to 2015-16, which is roughly 4.77 crore and part of 4.27 crore out of this whole 18 crore basket. Now, within this amended definition, because my lord knows that in the era
Yes.
when there is no definition of government, one has to look into the General Clauses Act. My lord, and the General Clauses Act I had included at page 623. Page 623, General Clauses Act. Entry 23.
Page
623. So in the definition of government, General Clauses Act operates. That used to say government or the government shall include both the central and the state government. So it did not have any preconditions or caveats of what kind of operation, etc., etc., unlike what the definition clause says.
Yes.
That was my submission. Now for the subsequent para, when the definition came about, now kindly see what the definition spoke about. If my lord quickly turns to page 309. It said government means, it is my respectful submission that I fall under the very first line, departments of central government. Because anything and everything that I do has the blessing of the central government. Nothing that I do can happen without the approval of the central government. And my lord saw the exemption from Insurance Act, the exclusion from the Insurance Act, all of that was by the central government. So according to me, my respectful submission is the definition of the government means the department of central government. I should fall under that. Assuming there is any doubt, we work further up. A state government and its department and a union territory and its department, but shall not include any entity, whether created by a statute or otherwise, the accounts of which are not required to be kept in accordance with Article 150 of the Constitution.
Yes.
Which means that defining moment is show that Article 150 operates on you as an entity. That is the defining moment.
Yes.
Now Article 150, if the Lord has the Constitution, I will not trouble. It is not very material. All that it says is form of accounts of the Union and the states. The accounts of the Union and the state shall be kept in such form as the President may on the advice of the Controller and Auditor General of India prescribed.
Yes.
So it has to be in accordance with the CAG's directive. That's the long and short of it.
Yes.
Now, if my lord comes to page 624.
Yes. Yes.
This is the Government Accounting Rules 1990, issued by Ministry of Finance, CAG. Lord sees that.
Yes.
If my lord turns to page 625. Clause 6. For the sake of practical convenience, the forms of accounts including appropriation accounts relating to railways, posts, telecommunications and defense department may be determined by the departmental accounting authorities within such range and covering such aspects as may be prescribed by the central government in the Ministry of Finance, Department of Expenditure, Controller General of Accounts, on the advice of the CAG. The provisions of Article 150 of the Constitution will be deemed to have been satisfied if the forms so determined are not questioned by the CAG or the Controller and Auditor General of India. So there is a deeming provision that 150 operates for defense departments. And I had pleaded so at page 69, para 118.
Yes.
Page 69, para 118. Lord has that? Page 69, para 118.
69.
At the foot of the page, below? Yes. Para 118. That in this regard, the petitioner submits that as it is nothing but a scheme run by the Department of Central Government, i.e. the AR, in essence, it too bears the trappings of Department of Central Government. Moreover, the petitioner also has its accounts maintained in accordance with Article 150 of the Constitution, which in turn stipulates that the accounts of the Union and State shall be kept in such form, etc., etc. To buttress the foregoing, the petitioner draws reference to Rule 6, etc., etc.
Yes.
So even when the definition came in, which said government entities will have to be those that are under 150, Article 150, I fit that as well. Not only that, kindly have page 333.
Page
333. This is to show that I am a department of central government. This is dated 28th of March 1960. In exercise of powers by subsection 1 of the Army Act, the central government hereby all the provisions of the said act to the personnel of the training instruments of Assam Rifle being a force raised and maintained in Indian authority of the central government. During the period they are attached to the army regimental centers of other army units for etc., etc. So it was set up by the central government. It is therefore a department of central government. Ab initio from 1960. And I'll show the transition provision little while from now. So therefore it is a force of the Union of India.
Right.
And the icing on the cake, my lord, comes to page 347. Lord has that, page 347.
Yes.
In exercise of powers conferred by 165 of the Assam Rifles Act, the central government hereby makes the following rules. So again made by the central government, and the next page, 202, talks about those compulsory deductions. Lord sees that?
Yes.
And 203 and 204 are very important. It talks about the repeals and savings and transitory provisions, in substance what it says is, after Assam Rifles came out from the Assam Act, from the Army Act, and got created the Assam Rifles Act, whatever happened under the Army Act continues to operate. So 204 at page 349. Any rule or order applicable to the force on commencement of this rule shall, unless repugnant to these rules, continue to apply unless and until abrogated or modified by the central government, etc., etc. So all pervasive central government department becomes writ large when these executive missives notifications are produced, my lord. Now, my lord, comes to page 342.
Member of the scheme.
This is the scheme, and this has to be read with.
Member of the scheme.
Yes.
2C.
2C.
Yes.
And this, what is there? This is Argis scheme 342 at page 342 has to read with page 345. At the bottom, my lord sees that. 345 at the bottom. This is the clincher. Audit of Argis accounts. All Argis accounts will be audited by CA as on the last date of every year. The Board of Trustees shall submit the audit report together with the accounts of fund and report on the working of the fund every year to the government.
Yes.
So the control of the government comes out from the scheme itself. It is not like a private trust or whatever else private CA doing and everybody is happy with that. It has to go back to the government, and that is how it is done, and that's why the deeming fiction, the rule 6 of the business rules that I showed, my lord, it's deemed to be under 150. Then my lord comes to page 407. My lord sees that?
Yeah, the fund shall be treated as an approved fund for the purpose of marking.
That's right.
Yes,
That's right.
Yes.
And here also at para 6, the Board of Trustees will prepare the accounts of the fund for every calendar year and submit to government for information together with report of the working of the scheme.
This talks of compulsory deduction, and this is a Ministry of Home Affairs letter. Yes.
And the Home Affairs letter. So the submission therefore I make is pre-negative list, not an insurance business.
Exempted, yes.
Post-negative list from 2012 to 2015. General clauses at government, all pervasive control, it is government. Even during the definition era 1/4/2015 onwards, Article 150 is the covenant. I satisfy that. And I would say not only one Article 150, I am also a department of the central government. This is the first line. So therefore, from all corners, I am covered by the exclusion from the levy by virtue of what these documents say. So it may not be appropriate or wrong on the part of the respondent to say that I am not a government in that context. That is point one, Lord. Now, the second point, I had said that how is it possible that the authorities in Delhi can carry out investigation, adjudication for people operating in Meghalaya. It was a jurisdictional issue I had raised, and as is necessary for a counsel to do, I was fair to the court and I quoted a judgment which was against me. Reddington, learned single judge of the Madras High Court, which my lord I had enclosed at page 719 of my petition.
No, first you come to Rule 3, correct? Service tax rule.
That's right.
Now,
that's the defining moment.
okay.
What their lordship, learned single judge, says at page 757.
Yes.
When Rule 3 of the service tax rules was placed into service before the learned single judge, this is how the learned single judge deals with it. As mentioned above, under Rule 3 of the service tax rules, the board can appoint any other officer to exercise power within the local limits, which is what my submission was. However, that would not mean that the officers of DGCI, presently Director General of GST, who are already Central Excise officers under notification so and so 38 of 2001 for whole of India, cannot exercise power on Pan India. Notification 22 of so and so is to be read in conjunction with notification 38. Therefore, what the learned single judge does, he makes rule 3 of the service tax rules otious. He says rule 3 of service tax rules is not of relevance. What is of relevance is notification 38. That is what the long and short of it. Now, my lord, with greatest respect, this is what I pointed out. I am re-emphasizing this point. Well, it is a well-known rule that legislature does not legislate in vain.
Yes.
If my lord takes the impugned notification, which is at page 328, for a minute. That's right. Because a preamble of a notification also shows the source of power. Page 328.
Yes.
The preamble says, in exercise of powers conferred under 2B of the Central Excise Act, read with 65B 55 of the Finance Act, Rule 3 of the Central Excise Rules, and Rule 3 of the Service Tax Rules, which means they are drawing power from all of them. And if you are drawing power from all of them to satisfy the competency, then you cannot say that Rule 3 of Service Tax Rule will have to be ignored.
Yes.
And what is of relevance, my lord, is, for a minute, if my lord sees 38 of 2001, which is the fulcrum of the learned single judge, which is what he says in that paragraph, which is at page 326, which is where the mistake with greatest respect has happened before the Madras High Court. 38 of 2001, which is at page 326, may I read it slowly? In exercise of powers under 2B of the Central Excise Act, Subrule so and so, the Central Board of Excise and Customs appoints the officers specified in column 2 of the table below as Central Excise officers and invests them with all the powers to be exercised by them throughout the territory of India of an officer of Central Excise of rank specified in corresponding entry in clause 3 of the table, such powers being the power of Central Excise officers conferred under the said Act. That said Act is the Central Excise Act, not the Finance Act. Service tax is not administered under the Central Excise Act. So when their lordship, the learned single judge says at para 192, kindly have page 757 for a minute, my lord.
That they have the power to excise throughout India.
That's right.
Yeah.
So the reliance placed on 38 of 2012 was qua the Central Act of the Central Excise Act. And Rule 3 is more specific to us, which my lord will find at page 325.
Yeah.
325, my lord.
Yes.
The Central Board of Excise and Customs may appoint Central Excise officers as it thinks fit for exercising the power of Chapter 5 of the Act, which is the Finance Act, within such local limits. Otherwise, Rule 3 becomes nugatory. Such an interpretation cannot be countenanced where one rule is made to become a surplusage. My lord, in this regard, I place 3 decisions to Constitution Bench judgment. I'll just quote the para number, I will not trouble. Give Hansoli. My lord has that?
1 second.
Yes, sorry.
Yes.
This is Constitution Bench, 2002 7 SCC 273, Union of India versus Hansoli Devi. My lord, may come to para 9. Lord has that? Para 9?
Yes. Before we
embark, my lord may skip that part. Come to the next page. Placitum between placetum C and D, the line starts with Patanjali Shastri J, CJ.
Yes.
I read from here.
Yes.
Patanjali Shastri CJ in the case of Ashwini Kumar Ghosh versus Aurobindo Bose had held that it is not a sound principle of construction to brush aside words in a statute as being inopposite surpluses, if they can have appropriate application in circumstances conceivably within the contemplation of the statute. In Quebec Railway Lights Heat and Power Limited versus Vandry, it had been observed that the legislature is deemed not to waste its words or to say anything in vain, and the construction which attributes redundancy to the legislature will not be accepted except for compelling reasons. I'm afraid, my lord, there is no compelling reason for us to ignore service tax rules where it deals with Finance Act. That is one judgment. Other is Utkal, a division bench judgment, para 9 again. Because these arguments were not made before the learned single judge in the Madras High Court, my lord, with greatest respect. Utkal, my lord, is 1987, 3 SCC, 279, my lord has that. Kindly have para 9.
Yeah.
In considering the rival submissions.
Yes.
My lord, may skip that page. Kindly come to the next page, 7th line from top. The line begins with the word, it is again important.
Yes.
It is again important to remember that Parliament does not waste its breath unnecessarily. Just as Parliament is not expected to use unnecessary expressions, Parliament is also not expected to express itself unnecessarily. Even as Parliament does not use any word without meaning something, Parliament does not legislate where no legislation is called for. Parliament cannot be assumed to legislate for the sake of legislation, nor can it be assumed to make pointless legislation. Parliament does not indulge in legislation merely to state what is unnecessary to state, to state or to do what is already validated. And the third judgment is Calcutta Gas, which is on the same line. I will not boil the ocean with the same jurisprudence, but I'll just submit Calcutta Gas, para 9. So therefore, my respectful submission is, the learned single judge of the Madras High Court in that paragraph, para 192, ignores Rule 3. That was erroneous. Relies upon 38 of 2001. But that was qua the Central Excise Act and Central Excise Act alone, not to the Finance Act. And once Rule 3 says local limits as defined by the Supreme Court decision I had quoted last time, which was in the case of Diamond Sugar, had held local limits being within the state. Para 11. I had given earlier, I'll just read para 15 of that judgment of the Constitution Bench. The etymological meaning of the word local is relating to or pertaining to a place. It may be first observed that whether or not the whole of the state can be local area for the purpose of 1852, it is clear that to be local area for this purpose, it must be an area within the state. So when the Finance Act says local limits, it has to mean state of Meghalaya and state of Meghalaya alone. Somebody sitting in Delhi cannot be wagging the wand of adjudication in investigation cooperation that happens in the state of Meghalaya. That was my respectful submission, and therefore to that extent the very inquiry, show cause, proceedings was all bad in law without jurisdiction. So that was the second point. Third, so far as bias is concerned, my learned friend said under Finance Act, Service Tax Act, everything else, usually it is the practice that it is the investigator who issues the show cause notice and adjudicates. That's what he says, that the real separation of the magistrate from the adjudicator happens only at the appeal level. That was his submission. The architecture of the whole finance department is such that departmental level, it is the same person who does that. I asked myself this question, if that be the case, why on earth was this notification that was issued by the central government under GST, notification 2 of 2017? Because past practices became bad, where bad was realized by the government, and they corrected it under GST.
That's the own cause.
That's right.
Yes.
That is because mainly because the practice was going on for the longest time does not make it a good practice, and the government realized that. In GST, this notification was issued. Kindly have clause 1A, clause 3A.
For the identical authority.
Clause 3A of this notification. May I read? It starts with a non-obstante clause.
Yes, notwithstanding. Yes.
Notwithstanding anything contained in para 3, the additional commissioner or joint commissioner of central tax, as the case may be, subordinate to the principal commissioner of central tax or the commissioner of central tax as specified in column 2 of table 5, are hereby vested with the powers as specified in the corresponding entry in column 3 of the said table. This table 5, my lord, will find at there is no page number, at the end, my lord, at the end, table 5.
Amazing. At the end.
At the very end
of this document.
Of this document.
Yes, second last.
Second last or third last page, my lord, table 5.
Yeah.
And see the architecture here. Power of additional commissioner, joint commissioner of central tax for passing an order or decision in respect of notices issued by officers of Director General of Goods and Service Tax Intelligence.
Yes.
Clearly saying that intelligence authorities will not get into adjudication because he will be interested in the outcome. That is what audio alterum partem is. Fair hearing, no man can be nemo judice, that maxim allowed, no man can be a judge of his own cause. That is why under GST they segregated them, saying that you investigating authorities, you once you complete investigation, pass on the file to these people. And the description power, kindly see on the right column, passing of an order or decision in respect to notices issued by officers of Director General of Goods and Service Tax Intelligence.
Yes.
So it will be wrong to say that that is how it has been and that is how it should be, because they have corrected it under GST. And my lord, another thing of importance, under tax laws, it is always said, merely because something may have prevailed for a longer period of time does not mean that that influx of time justifies the levy or justifies the validity. There is now no such assumption in that case. There are cases, my lord, section 377 of the IPC got struck after 100 years. So efflux of time does not give legitimacy to any action so long as it is not correct in law. So therefore, that point also does not hold water so far as the bias part is concerned. And insofar as delay is concerned, my lord, I will not boil the ocean. Facts are writ large. 8.5 years. No justification beyond saying it's a complex matter. Complexity is your core competence. That is why you are an officer. If you say that complex matter, therefore I will not follow the timeline. That too which is provided as 1.5 years or 1 year and wait until 8.5 years does not justify any such action. And what is of relevance is, they say that we took time in going to the government seeking an exemption, etc., etc. I ask myself this question, assuming that be the case. Your law says, section 33A, I had submitted last time. Can you give section 33A? An assessee, as is well known, will be within its rights and limits to address his grievances the way he knows, including probably going to the policy maker, and that is what Argis did. But merely because I went there does not mean that your duty stops, because according to 33A, my lord has that, I have just submitted.
Yes.
This is about adjudication proceeding. I am referring to the proviso. Provided that no such adjournment shall be granted more than 3 times to a party during the proceeding. At max, you could have given me a laxity of 3 times. But beyond that, you also did not have the power. You had to pass the law in accordance with the concerned provision which says as far as possible within so and so period. Which is a mandatory provision. And there are enough judgments that I have submitted. I will not boil the ocean, my lord.
Yes.
So therefore, my respectful submission is, having dealt with all the 4 replies submitted by my learned friend, none of them with greatest respect are justiciable or justifiable in the eyes of law. They are fraught with imperfection, and therefore the whole proceeding and the whole levy, show cause, everything is bad in law without jurisdiction, and it should be quashed. 18.22 crore on a fund which is taking care of the people in uniform for a period from 2011 to 2015. We are today in 2016. I shudder to think the amount of interest for 10 years. The money, where will it come from, is also, I know equity does not have any role to play in tax matters, but this is a very important point to be noted also. This is a central government fund for the men, and a fantastic show cause notice of this kind, high-pitched demands of 18.22 crore without jurisdiction cannot be countenanced, my lord. That is my submission. I rest my case, my lord. We'll submit a written
point. Delay, DGCI.
4 points.
4 points.
Intelligence. No, 4 points. You're arguing 4 points. Yes. You're going to delay DGCI, then intelligence and on merits.
That's right.
Right. Those are 4 points.
That's right.
I answered. I tried to reply all the 4 points.
Yes.
And I've counted that. So, my lord, with liberty may be given to give a written
But
submission.
please, you limit the submissions to,
These 4 points.
to very concise.
Very
Because
concise.
the earlier case, I think the judges were ready, but we're still putting finishing touches since
Very well, my lord.
they were very, occupied.
Very well.
That is the thing that we just rounded up. So at least concise. We don't
Very-
want 44 or 50 page.
Very well, my lord.
You give it in, you can give it in a soft copy also. It'll be easy also for.
Very well. 2 weeks time, my lord. By
2 weeks.
by June.
First week of June, my lord.
Yes.
It may be kept CAV, my lord. We will supply in the meantime.
Yes, huh? Yes, 2nd June.
It may be CAV, my lord. We will supply.
Yeah, we'll submit it.
Sometimes it doesn't come. If you
It'll come, my lord. My lord,
Make sure it comes on.
Yes,
my lord has
sir.
had experience with
Yes.
me at least, so it'll come.
Hearings concluded. Judge preserved. Parties submit their written note subject on submissions, brief note submissions on 2nd June. Yes, 2026. In both hard and soft copies. Yes.
No, the interim order may continue till the.
Interim order, of course.
Yes, I'm so obliged, my lord.
And we have meeting to open. Yes.
Any mention?
Yeah.
Lordship, the hearing item number 29, I'm supposed to produce the original record.
29, which one?
29, Your Lordship, that
Junjanwala.
Judul, yes, Lordship. So, Your Lordship, that true copy we have made,
Have you flagged it?
we have flagged it.
Why does it ask for the records?
No, record is the original records are there. Original records are there.
No, why did we ask for the records?
Original record to see that that military land authority.
Order, Lord, if your Lordship would recall, order of the board was one line order. That
Not
we
one line
considered
order.
and
This
We'll post it tomorrow.
And
We'll post it tomorrow. So we'll have a look. We can examine the records
Yes.
while we're all here. Right. Just
and
enough
the copy may be provided
Yes,
to us
yes.
also.
Oh no,
Lord,
copy
so that
you.
we-
Whoever's here, who has your Mr. Silvesi,
also-
he can examine it.
Yes, Mr. Khera is there. Mr.
Yes,
Khera
Mr.
is
Kera,
there.
Mr. Kera is. Yes,
I'll
tomorrow.
give to you. Tomorrow, Your Lordship.
Tomorrow. We'll put it tomorrow. Yes. Tomorrow. Yes. Yes.
Yes, may please, Lordship. Lordship, I beg to seek your kind indulgence, Lordship. May kindly have a look at this, Lordship.
What is this?
Lordship, this is a letter from NHIDCL, Lordship. Here, now because of this letter, Lordship, the registry is acting on this without any formal order. Lordship, we have filed 3 petitions last week. Paragraph 3, Lordship, may kindly see.
Okay.
Lordship, they're insisting for prior notice, Lordship, to NHIDCL, Lordship. Because we have served
NHIDCL.
we have served them, but then they are not receiving, Lordship.
Who's not receiving? No, this is an internal thing. This is not for.
Mr. Pandey is occupied right now, Your Lordship.
Yes.
Mr. Pandey is occupied right now, so they have came forward to us for initiating a copy, but the copies are to be sent to the department. Then only will be endorsed to us, Your Lordship.
Then you
They
said,
have their local councils here, Lordship.
we
But then,
cannot- we
Lordship,
cannot
do you have
accept
standing
that.
councils?
they are standing councils.
Are you in the panel? Are you designated in the panel?
No, S. Pandey
Lordship,
is-
their names are there copied
There is
to.
a Pandey company. What do you want now?
Lordship, may kindly see at the bottom.
No, no, yes, I
also.
understand.
Lordship, we have served them,
The thing
Lordship.
is that they want to streamline process
then we
because
have-
sometimes without instructions, maybe the councils are making concessions. Already,
But it's causing us
to streamline process, otherwise, I can't only pray the office issue instructions council for the claimants to route any petition application received to the office and not to directly the council appear for the department.
We're facing difficulties, Lordship, in filing petitions. Lordship.
No, let us. I'm just side. Put it. Yes.
Lordship.
Lordship, I beg to mention one matter to be listed tomorrow. The writ petition is in the course of filing to the Lordship. Lordship, the public hearing is on 22nd of this month, Lordship. There is some urgency in this matter, Lordship.
Public hearings for?
This is regarding, Lordship, what happened here, Lordship, that lease was executed by the Ilaka of Nongklim Ilaka, Lordship, by the Doloi of the Nongklim Ilaka,
Yes.
for leasing out more than 200 hectares of land to the cement company, Lordship, for mining, for carrying out the mining activities,
Yes.
Lordship. So the State Pollution Control Board has called for a public hearing on 22nd of this month, Lordship.
This is Friday.
Friday, Lordship.
Yes. So what? do
So
you want?
I'm just praying that
You want to stop it?
my Lord, I have a prayer because we are the landowner, Lordship, because there was no consent from us, Lordship.
Can you effect notice to have any effective hearing before the 22nd?
My Lord,
Okay,
my
then we come tomorrow.
well, tomorrow.
Yes, yes, make it quick. What I mentioned.
Please,
Yes.
Lordship, I beg to mention item number 27, Lordship.
Yes.
Due to personal difficulties, Lordship, after 1 week, Lordship.
Lordship, as it is, nothing remains in this matter, my lord.
1 week, Lordship.
So nothing remains. What are you going to do? Withdraw the matter?
No, Lordship.
Then? After 1 week? Okay, yes.
And you, Lordship.
Your Lordship, item 30, Your Lordship, I'm praying if I may be allowed to withdraw, Your Lordship. With a liberty.
30?
Yes, Your Lordship. With a liberty to file fresh.
Okay, yes, normal order. Yes, so and so please for MS Ipajo.
Yes, Your Lordship.
All right.
Usual order withdrawal with liberty. Yes. Yes.
Please, Your Lordship.
I beg to mention item number 23. Lordship, I pay for 3 weeks' time.
23 weeks time. Why 3 weeks time?
Your Lordship,
What is the reason?
the conducting counsel is on bereavement, Your Lordship.
Who is the conducting counsel?
Mr. Ilal.
Okay, yes. No objection?
No objection.
Yes. Yes, make it quick.
Please, Your Lordship. Your Lordship, I beg to mention item 22.
Here for whom?
I'm for
Who's
the
the
respondent
petitioner?
3 and 4.
Are you informed the petitioner?
We've informed them, Your Lordship.
Okay, yes. Yes. Yes, yes.
Supplementary list item number 1.
Lordship, please, Your Lordship. Lordship, that matter may come at the end of the bond.
You may have it tomorrow, my lord. I will take instruction in this matter also in the meantime, because MIDC is one of the party in
What
this
is
case.
this?
It's questioning the sale deed, my lord. Questioning the sale deed executed by previous Sardar, my lord.
Lordship, end of the poor, Your Lordship. This
Basically,
tomorrow,
it's
Your
part,
Lordship.
my lord.
End of the poor, Lordship.
Lordship may have it tomorrow, my lord. Today I'm some difficulty, my lord.
Tomorrow, if general, yes. Yes.
Chief, here the petitioner was appointed as an UDA by the office of the Garo Hills UDA, by the office of the Garo Hills Autonomous District Council, Lordship. That with the enactment of that 1994 Act, Lordship, taking over the schools, District Council School, Lordship, he was a non-teaching staff, Lordship. So after that, his service was taken over by the state government, Lordship, and he retired on 2005, Lordship. Now, although there were several communication between the department, Lordship, but his service has not been regularized, Lordship. So I am relying certain judgment passed by this honorable court, Lordship. My case is similarly situated with that the petitioner in that
Will accept notice.
Will accept notice, Your
Lordship,
Lordship, for 1 to 6.
Yes, Learned Counsel Petitioner issue notice. MS T. Yangi B. Learned EAG is present with Son Rinja is present on behalf of respondents 1 to 7.
1 to 6, Your Lordship.
Treasury officer, you want
1 to 7.
Treasury officer, yes.
1 to 7, so no further notice required. MSV Pasa is present on behalf of respondent number 8. Yes, this after 2 weeks for
Instructions, Your Lordship. 3. Yeah, that's where's the file?
Yes.
May please, Your Lordship. Lordship, this is the second round of litigation, my lord. So this is a pension matter.
What
Yeah.
happened the first round?
First round, my lord, the Lordship has passed an order dated 1/12/2020.
This was recovery of
For the
overpayment.
25.
This was a
For the recovery, my lord,
Your
payment.
Lordship, where notice had been given.
But thereafter, my lord,
Then
gratuity.
Your Lordship's order dated 1/12 has directed that out for, because of his financial difficulties and all that, only 50% should be recovered from him. According
That
to
was
the
already
Lordship-
recovered, my lord.
Yes.
But now pension and other benefits has yet to be released, my lord.
So we'll take instructions, Your Lordship, because 80% of the DCRG has already been released.
That has been
Leave
given, my lord.
encashment also
Pension has not
50%
been
has
given.
given.
Is a little lesson now.
Lordship.
Has it lessened your
They've got
financial-
more than
my lord.
16,
But
17
they have
lakhs.
already deducted.
Has heard Mr. A.G. Moment, Leonard Council, that issue notice, MST B. Leonard
Abraham.
A.G. present with H. Abraham, present on behalf of respondents 1 to 8, and was for 9, no further notice required. This other 2 weeks, yes.
Lordship. Hello, Lord.
Lordship. 4.
Please, Lordship. Lordship, this matter pertains to the non-payment of family pension, Your Lordship.
Any pension?
Yes, Your Lordship. Your Lordship.
When did his husband,
No, Your Lordship, he is my father, Your Lordship.
when did he die?
Yes, Your Lordship.
When did your mother die?
Your Lordship, he died on 22nd of 1982, Your Lordship.
82?
Yes, Your
And
Lordship.
your mother?
Yeah, my mother, Your Lordship, she died on 24/12/1989, Your Lordship.
So 89, you not got family pension till now?
No, Your Lordship, the case here is that, Your Lordship, my father was in receipt of the family pension during his lifetime.
Okay,
Thereafter,
yeah.
my mother received the family pension, and upon her death, my sister, Your Lordship. And now, Your Lordship, upon the demise of my sister, Your Lordship, I am the unmarried daughter, Your
Your
Lordship.
sister also died.
Yes, Your Lordship.
Yes, heard MSGC Mulwa file after the council petitioner. You should notice Dr. Imroz Yazi J.I. is present with MS C. Jala on behalf of the respondents. No further notice required. Just up to 2-3 weeks for instruction affidavit. Yes.
Daily list item number 1.
Lordship, I am praying if this matter can be taken up at the end of the board, Lordship. The senior is on legs, Lordship. This is that review petition, Lordship, against the order of second appeal.
Yes, no objection, Your Lordship. We can.
You ready? End of the board?
Yes.
After 2.
Lordship.
Yes. Are you injured or something?
No, motorcycle accident.
What's your name?
Arling Dog.
Yes.
Number 2.
Item 2 and 3, contempt petitions, my lord. Lordship, in terms of
Regarding?
Lordship's order of 24th
Pending before the division bench, Your Lordship.
Yes,
awaiting the outcome.
And
Your
it's
Lordship.
reported that the appeal is still pending consideration. So the bench this matter of the 3 weeks.
4.
Connected matter, the appeal.
May I please, Lordship?
Yes.
Item number 4, my lord, against the order dated 18 March 2025, my lord. SLP was prepared and it was dismissed on 5 January 2026, my lord.
This is up to number 4.
Dismissed the same.
All these matters connected, Dr. Mozika.
Well, 4 and 6 are connected, man.
4 and 6 are connected, my lord.
Yes.
They have preferred a review petition, my lord, against the dismissal of SLP, which is still pending, my lord. And the review petition was filed on 27 February 2026, my lord, but still in defective position, my lord.
A defect has been rectified, my instruction.
Okay, you get up to 2 instructions. Otherwise, review Supreme Court is mixed. Unless is very. Yes, 4 and 6. Just up to 2 weeks. Just of 3 weeks. Wait for the instruction from the SGI. Yes. 5.
Well, 5 is connected with hearing item number 21. We are saying that we have complied. They are saying it has not been complied fully, my lord. So they want to argue. The 5 and 21 are taken sometime, my lord. Maybe next week.
5 and when?
5 and 21.
After vacation.
After
our short vacation, yes. Mr. Pathak, will you argue this matter? Yes, I don't know. This contempt matter is connected to W22.
That is also contempt, 21.
This,
21 is also contempt petition, my lord.
This instant matter as contempt case item 5. 30/2025 is connected to contempt case number 77/2024. In the hearing this,
my lord.
Pray that the matter be taken up after vacation, in the first week of June. Yes. Pray the Lord. We'll hear you. Yes.
My lord.
Yes.
Deep your lordship.
7.
No, Lordship. We will file the rejoinder, Lordship. I've already filed my affidavit, Your Lordship.
Yes, party submit that. Also, this matter returned back from mediation on being unsuccessful. You want GCH Marak paid for?
Rejoinder, Lordship. 2 weeks, Lordship.
And we say response allowed 2 weeks time by rejoinder.
Obliged, Lordship.
8.
Yes, sir. Up also. Yeah, MSG Nongput.
I'm Somat, Your Lordship.
You are?
I'm Somat.
Oh, so sorry. Yes.
Your Lordship, we are praying for 2 weeks' time to file the rejoinder.
Yes. 28/4. Yes, from the as paid 2 weeks for the 2 weeks time. Or it's the first time asking.
Yes, Your Lordship.
Yes, as paid 2 weeks time is allowed for rejoinder affidavit. Yes. Yes, answer. Yes.
9.
May it please, Your Lordship. Lordship, I pray for further 2 weeks' time, Your Lordship, to
How
file
many times you
rejoinder.
prayed?
This will be the 3rd time, Your Lordship.
Yes. Third and final penalty granted of 2 weeks for rejoinder. This is after for hearing.
10.
This matter was sent for mediation, but could not be settled, my lord.
Who's the petitioner?
Not petitioner, counsel is...
PT Sama, where's MSDCH Marbo? Sorry, this is Marakyo. Yes. Samar, yes.
So thereafter, my lord,
you have
we
filed affidavit?
Thereafter we received instructions, but I feel we'll require more additional instructions.
Yes, the matter is returned back on the... It's already written. Last time who appeared in this matter? You or Zeri Nokandri?
My lord, she appeared, but I was not available on that day, my lord.
Yes, Mr. Kivarasi today on behalf of the response based on the lot further 2 weeks time to file affidavit, yes.
I give this worship.
11.
My lord, we have filed our rejoinder affidavit to the counter affidavit of respondent number 3. From our side, my lord, all pleadings are completed.
What's the matter about?
This is registration of Assam Rifle ex-serviceman registration.
Oh, what about
Kerala.
objectionable?
My lord, the issue basically here was, my lord, that there were 2 organizations which were being floated.
No, I know. They've been taken off the objectionable videos.
No, my lord, we have filed an additional affidavit saying despite the assurance, they have still uploaded objectionable videos. And my lord, not just that, in our additional affidavit, we have given the URLs, we have given a transcript of what they are speaking about. Take
them down. Where's Mr. Shilla? They've been taken down.
This has been, these videos
Where's
are...
the affidavit? It's
my lord, it's there. The additional affidavit is on.
You filed today?
No, my lord. On the last date, court did not sit, my lord. So we have filed it in the intervening dates. We have served a copy, and these videos have been uploaded after the assurance.
Mr. Dakhar. Yes. Mr. Dakhar, the last date, this matter appeared before the court on 10/4/2026 on behalf of respondent number 3 has submitted that pursuant to orders of this court dated 10/3/26, the objectionable videos that were reviewed on YouTube had been taken down. Stop. Next para. However, same sentence. Stop. Same line. However, Mr. N. Khera, learned counsel for the petitioner, has submitted that fresh videos.
My lord.
Fresh objectionable videos have since been uploaded. Stop. To which he submits an affidavit has been filed to bring the same on record. Stop. Next para. Mr. F. Dakhar. To obtain instructions on this matter after 2 weeks.
Yes.
For hearing.
My lord, pleadings are completed, matter can be taken up for hearing.
As reported pleadings are complete, as submitted pleadings are complete, it's a matter for hearing. And for instructions. Don't upload those videos.
My lord, actually in certain videos they have also wielded indirect threat to me, but they have also spoken about the proceedings, these proceedings in the court. And
have they done that? If that they cannot upload or refer to the proceeding without the permission of the court.
My lord,
it happens. It's not the first time now. This live streaming will have severe repercussions because we're hearing complaints from certain people where certain clips of certain proceedings here. There's no YouTube.
My lord, they did not
submissions made by counsel or by the court have been they've been spliced in and they say
they have not
little news channels that they're floating for podcasts or whatever.
My lord. My lord, they have not I fairly submit, my lord, they have not taken out any of the proceedings from YouTube and uploaded it, but they have uploaded their videos where they have spoken certain things, my lord, which is in the grey area with regards to the proceedings in the court.
Then we have to stop this. We can have only virtual hearing. Live streaming is...
With this proceeding, they have made certain comments
not only this proceeding,
should not have been made by them.
Suppose court makes some remark about some authority from that. Now that's come out.
My lord.
And it's just a certain one sentence read that court has done this.
Out of the context.
A lawyer cannot answer this, like all these things are coming. So, reflect very badly also. Those have come, and there are some clips because we have intelligence that monitors this thing, and complaints have come.
Interim orders.
Yes. Interim orders continue.
Well, there is an interim order with regards to the collection the money in the name of.
Yes. Interim orders continue till further orders. Yes. Next item.
Well.
Lordship, the affidavit is ready. We will find it within the course of the day, Your Lordship.
What's the matter about admission?
Academic.
Oh yes, okay. You're Mr. Sorry?
Slamat.
Your file.
Actually, my lord, it was my affidavit. We're not filing for this matter, my lord.
The counsel for 127. Submit the appeal file across the day. Yes, please to rejoin the event. Yes.
Much obliged, my lord. 13.
Your Lordship, in this matter, we're supposed to file an application for striking off of respondent number 5 and implementing a new party,
Why
Your
you
Lordship.
filed it? That was since 28/4.
Your Lordship, I'm just praying for some more time, Your Lordship.
What's so difficult?
Due to a few alterations in the application, Your Lordship, we have to resend it to Chantia.
The Contempt Petitioner pays sponsor for the 2 weeks time to bring an upload application for implement. Yes, just about 2 weeks. Any submissions? No.
No.
14.
Let me order you. Yes, he appearing on.
We received instructions to appear, Your Lordship. Will
Yes,
take notice.
And AG has entered appearance today on behalf of the respondents. All the respondents.
Yes, Your Lordship. All the respondents.
She prays for about 2 weeks time to obtain instructions and to file.
We haven't received a copy of the petition.
We'll serve them a copy, my lord. Yes, yeah, she further submit a copy of petition yet to be received. Yes, Mr. SD assures that within the course of the day, copy will be served.
15.
Affidavit in opposition has not yet filed, my lord, in this
When is
matter.
the matter filed?
It's a very recent matter.
Yes, 3 weeks for the time has period allowed by affidavit.
My
16.
lord, deep your lordship.
16.
Here also I'm required to file an affidavit only.
When is the matter filed? 25, 26.
26, Your Lordship.
April 20.
Now you already promoted.
No, Your Lordship. Your Lordship, here also we are praying for retrospective promotion, Your Lordship.
It's already been approved.
Your Lordship, that is why we are aggrieved, Your Lordship, because
the
that
date regularization.
Your Lordship, because that letter that was placed on board on the last occasion, Your Lordship, we have enclosed that letter here in the writ petition also. They've not acted on that letter, Your Lordship. It's just
You file the affidavit, Dr. Mojika. When?
We'll file. In fact, there's some problem with signature. Is affidavit ready? We'll file when next time.
Your Lordship, here we're praying for retrospective.
I will let the affidavit come on
Yes,
board.
Your Lordship.
Yes, Dr. Mojika prays for the 1 week's time. For affidavit, yes.
10 days time.
10 days time.
17.
Obliged, Your Lordship.
17 also I'm praying sometime.
That BSF fellow?
Yes, my lord.
But next day we'll file it.
You already filed?
No,
No, my lord.
I'm praying for some time.
I think you better. They're not going to let you go.
Probably appears so, my lord. The smile says.
You let them go. Let them go.
Take a permanent leave and go and study. We don't mind
They're
that.
not going to let you go. You're in charge of the entire Indo-Bangla fencing.
That is why so much of foreigners entering our country, man. One person.
Yes. For the 2 weeks time has been. That's what they've said. You're most important person.
Yes.
You're in charge of the entire, as per their submission, entire Indo-Bangla fencing is under your control.
My lord.
Yes.
Check the nuts and bolts.
18.
But here I'll appear for 4 and 5.
6.
The 6 steps have been taken, but if I may submit, Your Lordship, we've just received instructions, Your Lordship, that remeasurement of the area has taken place. We may place these instructions.
Who will appear for 4 and 5 is Dr. Mozika. Then
1, 2, 3 state.
1, 6, 1, 5. 1, 4 and 5.
1 also. 1, 4 I'm missing. 1, 4 and 5.
State is a formal party in a sense, my lord, that the notification is issued by
6
state.
is the Dorbar.
For measurement carried out by NITs.
But as per the number 6 is the Dorbar, Your Lordship. But as per the new instructions that we just received, respondent number 6 will not appear, Your Lordship, because this matter may be closed because the remeasurement has already taken place. I've placed the
You have
instructions.
instructions?
No. So you want to close it?
Yeah. Because we
Yes,
are happy,
remeasurement.
we're happy with the remeasurements, Your Lordship.
You're satisfied with remeasurement.
Your Lordship. These are the additional areas that have
But
been
it's an
added.
official document which has been sealed, signed and sanctioned.
Your Lordship, if you may take at the bottom of the pages, there are the signatures of the authorities.
We have signature of the Deputy Commissioner.
The last
we just
signature,
record, we
Your
just
Lordship.
record, just a brief order. MS T. Sutunga, Learned Counsel for the petitioner. Dr. N. Muzika, DLGI, submit that he also be representing the respondents number 4 and
4
5.
and 5.
Stop, apart from respondent number 1. Stop. Mr. Learned Advocate General has submitted on behalf of the respondents. They are not necessary.
2 and 3, my lord.
You have no role to play. That they have no.
No, my lord, we issue notification based on the measurement carried out by NHIDCL
Okay,
and the
submits that notifications are issued by the said respondents on the measurements made.
measurement carried out by
NHIDCL.
Yes.
However, MS Nekpara, MST Tutangato submitted that the matter has since been resolved as much as the respondents 4 and 5 have
They've remeasured the area that has been acquired.
have
for the
undertaken the
construction.
exercise of remeasuring the area sought to be acquired, to which the petitioner is satisfied.
The only limited prayer, Your Lordship, is that at page 18, regarding the correct DGPS coordinates that have not been provided to us. If there's
Yes,
just a direction on that,
she
Your Lordship.
satisfied. Apart from, however, has also she has also submitted that, however, the DG, what's that called?
DGPS coordinates
The
of the
DG,
land that has been
the
acquired.
GPS coordinates that we provided stuff.
Then approach the department.
On a submission from the councils, it appears the matter can be closed at the stage itself, as much as the substantial prayer and petition has since been the grievance of petitioner has since been addressed. Stop. It's further provided for any other grievances such as supply of these coordinates, the petitioner has the ability to approach the sub-respondents.
Yes.
Yes.
Highly obliged.
Yes. Observe above, as directed above, or as ordered above, the matter stands disposed of.
Highly obliged.
19. 19.
The matter pertains to freezing of bank account, Your Lordship. I've served notice to all respondents.
In this matter, Lordship, I have instructions to enter appearance on behalf of respondent number 4. That is SBI, Lordship. I pray for 2 weeks' time, Lordship.
What's the amount?
The disputed amount is 6,05,000. However, the amount kept on hold is 3,50,000. Being the reason that there was
Your whole
insufficient-
account 6 lakhs. You have 6 lakhs in your account.
No. I have remaining amount was only 3,50,000. Disputed amount is 6,05,000.
He has already spent, withdrawn 3 lakhs, some amount, Lordship.
Already spent meaning?
He has already withdrawn the
After the freezing?
the amount of 3 lakh rupees from the disputed amount. So 3 lakhs is remaining in his account, Lordship. That has been frozen.
Mr. S. Pandey, as an appearance on behalf of the respondent number
4.
Respondent number 4, Lordship. SBI.
Number 4. What about number 3?
2 and 3 have taken steps, Your Lordship. They
Yes,
both are
sir.
complainants or cyber police, Your Lordship.
Yes, however, with regard to respondents, appearance on behalf of number 4 today. 4, right? 4. Then with regard to respondents number 2 and 3, the service report still awaited stuff.
Number 1 is, I'm appearing on behalf
Yes.
of number 1.
You already appeared last time.
I have appeared, Your Lordship.
MS Tiangi Bilan AG submits that she will be representing respondent number 1. Stop. On behalf of respondent number 4, Ms. S. Pandey has ended appearance. With regard to 2 and 3, service reports limited. How much time you want?
2 weeks, I'm Lordship.
Yeah, Mr. S. Pandey paid for about 2 weeks' time to file affidavit after 2 weeks for service report on 2 and 3 and for affidavit by number 4.
20.
Your Lordship, this is the matter regarding the Jingle and Yam. Your Lordship,
Yes, Your Lordship.
Well, there's some development, Manoj.
In
matter is the
WPC 183 of 25, there was some miscase filed by the petitioner.
order has been passed.
Some stay has been passed.
In this case?
Yeah, in the other case.
Your Lordship, last year.
Basing.
My lord,
Mr.
in my
Singh.
case, I have filed a miscase, my lord.
In your case,
in
which
my
case
case,
is
that was pending. There is WPC 183 of 2025. In that case, my lord, I have filed a miscase, and that miscase was heard yesterday, my lord, on an urgent basis, and there was a stay which was granted for today's rituals. That rituals is to be performed today.
Actually,
It is on 19. So the stay was granted. If I can,
Your Lordship, if I may just inform Your Lordship, during the last occasion when they came before this court, the last year ritual, they have said that we are not ready to perform the ritual. Through this court direction, the ritual was held, and after that we have submitted affidavit, and we have also made it clear that we will be performing the ritual. In fact, the petitioner, in the 5 meetings that were held in order to prepare for the rituals, he was present. Till yesterday, last night, we got the information that he filed this miscase. In fact, on the 14/4, 24/4, all these days, he was there. He did not inform us that he is not ready to perform the ritual. In fact, the dates, Your Lordship, was fixed today, on the 19th.
The ritual has been postponed now.
Postponed because of the stay order that was passed yesterday. Because of the stay order that was passed yesterday.
yesterday's order.
Stay order is it?
Without, we have not been heard, Your Lordship.
Now, what does the order say?
My lord, the order is yesterday's order.
Let's see. Long order.
Yes, ma'am.
Paragraph 8.
Paragraph 6, my lord.
Will it be a long order situation?
There is no.
We'll
in fact,
take up this matter when.
Because
now,
you're
now 19 will take up on 21st.
Hello.
21st. The dates for the ritual has already been fixed today. It'll end on the 21st. But
because this order can't
yes,
be held on 21st.
Now, my lord,
we have on the next date, the
that is
27.
27, my lord.
27 is the date that we can still fix.
Yeah. No, we'll have 27th holiday. We'll have
No, for the rituals. For the rituals.
21st matter, it will come prepared. Yes. And take down the miss case number 147/26 in the Proceedings 180/2025. Subsequently, this time, the parties appearing today have informed the court that in view of the order dated 18/5/2026, in the instant this case, the rituals which were scheduled to be held today have been.
Your Lordship, we may be allowed to file a reply to the miscase that was filed.
Has been suspended for the reasons stated therein. Mr. You are praying for which
Respondent number 4 in the respondent number 4.
Yes, sir. And Mr. Mr. Kriam, you are appearing for him. You file affidavit.
Actually, the record is there, my lord.
Yes, okay. Then
We'll file a short affidavit, my lord.
As the matter deserves some serious consideration before any further orders are passed. Let this matter appear on 21st May 2021. Parties to file whatever affidavits or objections to the miscase before the next date.
Your Lordship, I have a suggestion regarding the information that I've received. New dates have been planned. 27, 28, 29, 30th.
That's well and good. We'll have on 21st. That day you
A suggestion regarding the names of the representatives of the court that may
You can
conduct.
file anything you want before that if you are party here. We'll consider it on 21st. Just on 21st. As a fixed item.
Highly obliged, Lordship.
Yes, hearing at you ready? We'll take it up at yes. Number who's in the hearing? Yes, sir.
Hearing 24.
24, my lord.
Arrow, you take up at 2:15.
My lord, this matter, my lord, we have already issued the check.
Which one? 20?
24, my lord.
My lord, here, let the matter come up next week.
Why?
We have already issued a check, my lord.
Check. Only the difference amount of gratuity has been paid, but no interest, lordship. The difference has already been given.
My lord. He is.
My lord, there is an order to pay the gratuity along with the interest 6%, lordship. So now the difference exact amount, what I have given the calculation, lordship, my lord will kindly see my representation as per the order, lordship.
No, just tell how much, what is the
The
difference?
difference amount was 3,87,916. That has been paid.
What's the period of delay?
Delay of 15 years, lordship.
6% per day.
Yes, lordship. The interest as on March, lordship, on the day of filing of the representation was 3,45,886.
The interest only.
Interest only.
And the
Principal
and
amount.
the amount principal amount how much?
3,87,960.
Double now.
Not it's less than the principal amount, lordship. Now there is an order, lordship, because that 6% was given considering the financial.
Yes, we remember. Yes, we understand.
Yes, lordship.
You know, interest is
Now 15 years now he has been retired in 2011. The husband died.
you take that money for now, you can cash it interest, you will keep the matter open.
Yes, lordship.
Yes, though Mr. S.A. has submitted that the gratuity amount as entitled has since been released to the petitioner. However, Mr. S.A. Sheikh submits that the interest component is yet to be satisfied. So he prays the matter be heard.
Lordship.
Yes, this up to 2 weeks.
Must.
25.
Item number 25, my lord, if matter can be fixed after a week, my lord.
Why?
My lord, the state were supposed to file.
We were supposed to file the status report. We have got the communication, my lord. Where are the papers? My lord, we have communicated to NPCI, my lord. What NPCI has asked us to get the details from the bank because they have all these details.
Sent appeal with the opposite NCPS.
NPCI. Yes.
NPCA.
What is the latest status?
They made a requisition to us.
That fellow, what's his name? Mongol D or someone, what's his name?
My lord.
Where all the amounts went to? What
Subham.
Huh?
Subham. There is one person,
Kumar, yes.
Subham.
So has that fellow been apprehended?
No, my lord. We wanted details of his accounts, my lord, and we wrote it to the NPCI. And the details we had, we communicated to the NPCI, but they need some RRN number that we do not have it. So what they have informed us, my lord, to contact the bank. They have all these details. But all this while, my lord.
Where's Mr. Marpan?
All this while they said they do not have any details. But NPCI is saying they have all these details, my lord.
Then you'll pay penalty.
This is.
I don't understand. The thing is that the state have taken
They
my
have all these
statement.
details.
They should have asked, even in the report also they have submitted that they have come to the bank manager had come several times. They should have done that. Now, this is just a way of taking. We've given all the information. The statement already been recorded, Your Lordship. It's already there in the record.
Anyway, you don't need, you just file your report within 1 week. And then if the axe has to fall,
Actually, we've
you
done
have to
what-
stick your neck out.
all the questions that were put to us by the
After,
we've
Mr.
cooperated.
Ensign
Full
pays the
cooperation
matter
is there.
after 1 week to enable him to file a detailed affidavit.
Status report, man.
Status report, yes. On affidavit, yes.
26?
After 1 week, yes.
Obliged.
26.
May it please your Lordship. Lordship, this is an appeal matter, my Lord.
Yes.
Lordship, probate was passed, my Lord. Probate order was
You ready
passed.
to matter today?
Yes, my Lord.
Ready? We'll have it at after 2:15.
Lordship.
Second half is.
Lordship.
28.
The rest of the matters we'll have it at after second half, unless you want to join.
Lordship, it's a very short matter. In fact, it's a pension. It's a contested case, case of family pension between two wives, essentially.
Yes, last time I have filed a rejoinder affidavit. I have submitted to the
for hearing.
It's listed for hearing, Lordship, but my limited contention over here is because it's contested, the appropriate course for the learned petitioner, my learned friend, would be a succession certificate from the lower court, because they are.
I know, but where's the private respondent?
They've not been pleaded, Lordship. That's another problem.
Who's leading you in the case?
Oh, just me only. I'm the only concern.
Okay, very good. Okay, will you after our lunch you be here. We will take it up. Yeah.
Okay.
Similarly, other matters also. I think there's nothing left.
31, 32.
Yes, Mr. Jindal, you're ready with the matter 31?
Sorry. Item 32, my lord. I'm the petitioner in this matter. This matter
31
can,
also you're there?
31 also, my lord.
Yeah.
32, I'm the petitioner. If this matter can be taken next week, my lord.
Okay.
There is a connected matter, Your Lordship, which is listed on the 1st of June for hearing. So both of them can be taken.
Okay, 1st of June. The 31 is ready with the matter.
31 is ready, Lordship. 31, the court has already drawn the suo motu contempt against the officers interfering in the.
No, that's
That
already
has
been,
appeared
yes.
and he have been dispensed.
Because that is very understandable, because he was very candid. He's under instructions. That we will pass orders, yes.
So a detailed hearing will be required on this. This also can be taken next week.
Next week, Your Lordship, 31 also. 31 may also be taken up
The
next
tenure of the committee is going to expire very soon.
You all fighting among yourselves, what can we do?
Yes. No, but the director has decided the matters.
Yes,
Which
so that will have to be open, yes. Yes. Because who's appearing for the state? You're saying that
31, I am appearing for the state, Your Lordship.
last time Advocate General appeared.
Yeah, he is also
do some
appearing.
firefighting.
Yes.
Yes.
No, he is also appearing. In fact, he is leading us. But
Maybe he
today he's
appeared
got some
for the
difficulty.
contender.
He's got some difficulty today, Your Lordship.
Okay, after 1 week.
He's got to catch a flight or something.
Yes.
33? 33?
33? Yes, Mr. Nyuta. You're also ready with the matter?
Your Lordship, I just received instruction, Your Lordship, that the petitioner hearing has already joined in the department, Your Lordship, as a master role, which is equivalent to the post which she was terminated. So she is no longer pursuing this matter, Your Lordship.
Do you want to withdraw?
You may be close, Your Lordship.
Yes, Mr. D. Nyuta submits that the petitioner doesn't want to pursue the matter any further, and prays the matter be closed, disposed of. On such submission, the matter accordingly is closed and disposed of. Yes.
All right.
Second call, item number 1.
Hearing there.
Other side. We're already on my lord's lunch hour.
My lord.
After lunch?
After lunch, let come out.
Supplementary one, lordship has posted up tomorrow.
Which one? Connected to which one?
Supplementary one is not connected to this.
Supplementary one is tomorrow. This day. Oh, daily.
Can come out tomorrow also. Huh? It's not connected, my lords. That supplementary one is for motion. This is already, it's a review application for admission.
Apologies.
I'm getting confused, yes?
Show me the list.
This is regarding this is sir.
This is a review application, my lords.
No. And supplementary one Darvashtong.
Supplementary one is a different matter altogether.
This is the one now. It's a partition
called supply one.
Or tomorrow.
Lordship,
what happened?
Already been posted for tomorrow.
I think, my lords, in supply one, my lords have already passed on orders to be listed tomorrow.
Okay.
Where the Advocate General had appeared, my lords, I think.
Oh, yeah, it's not available.
My lords.
Yeah.
So, this is main list item number 1, my lords. It's a review application.
Okay.
You want to take it up?
Yes.
After lunch, then, my lords. My friend is here from the other side.
But someone else appeared with the injury, motorcycle injury.
Yes, what?
Mr. R. Lingdo.
What are different?
Yes, Arlington and
Who's appearing in this matter then?
Arlington and me.
You are assisting Mr. Lingdo?
Yeah, yes, I'll be assisting. He is here in our court.
And number 28. Yes, and 26. Right.
Or we could have this tomorrow also, my lords, subject to your lordship's convenience.
Tomorrow? Okay, tomorrow, yes.
Let it come up tomorrow.
But other matter will have it. Yes. That's obvious. 2:15.
I'll leave that.
Sorry, it's in a meeting. The CJs. How many matters are left? Since Mr. Movement insisted. Yes.
Lordship, is that matter, my lord, wherein the mother and the son, they're fighting over the. This is. Here what has
Okay. Yes.
What has happened, my lord, here in this matter, a probate order was passed, my lord, behind the back of the appellants on 13/5 of 2022. So, after learning about this order, the appellants filed an application before the same court, my lord, and also filed a misapplication therein. And instead of hearing the misapplication, the court below heard the matter on merits. And being aggrieved by that, my lord, we approached before this honorable court, and the lordship was pleased to pass an order directing the additional judge district council court to hear the matter on miscase first, misapplication for stay. And instead of complying with this honorable court, my lord, the additional judge proceeded to pass an order on merits and rejected my application on res judicata. The impin order, my lord, is at page 65, my lord, annexure 10.
Yes.
Here, para 5, my lord, if lordship sees, says like, I have examined the order 9/11/2017 passed by the Honorable High Court of Meghalaya, wherein it was noted that the matter pertaining to estate of late Atul Simarak had amicably settled between the parties, thus rendering further adjudication unnecessary. Consequently, this ruling holds significant weight regarding and subsequent petition filed on the same matter. And para 8, my lord, I'll just skip this portion, my lord. Para 8, give the above observation and the substantive evidence provided by the OP, this court finds that the petitioners are barred from filing the current petition due to the principle of res judicata. Now, the question of res judicata, my lord, is a mixed question of law and facts, my lord. Now, the learned court below should have adduced the evidence, my lord. Issue should have been framed, but he rejected
What's the order dated 9/11/2017?
My lord,
what does order refer to? I have examined the order dated 9/11/2017. Passed Honorable High Court of Meghalaya.
yes, okay, that is. I'll come to that, my lord. This is page 75, my lord, and this is settlement, my lord. As amicable settlement was reached between the father.
But it's not an order of the court, is it?
9/11/2017 is an order, my lord. It's page 75.
Okay. Okay. Yes.
The order, this order only says that the amicable settlement was reached, so no further consideration in regard to the merits of the case, my lord. But, my lord, my submission is that the amicable settlement has not attained finality, my lord. Why? Because the dispute remained, and because of that, they again approached this honorable court, and lordship was pleased to pass an order at page 85, my lord. Just see page 85, my lord. Annexure 14. The relevant portion will be at page 3, 4 and 5, my lord. Page 86, the relevant portion, paragraph 3. The grievance of the petitioners is that in spite of the terms of mediation agreement, the respondent had refused to comply with the same, which has compelled them to reapproach this court by way of the instant petition.
Yeah.
As noted, the sole respondent has since died, and as such, the entire proceedings that transpired before this matter came before this court and no longer relevant for consideration. The petitioners only pray now is that the matter be closed before this court and be allowed to seek appropriate remedy before any other court of law with regard to the properties in question. So the settlement, though it was reached, my lord, it has not attained finality.
The respondent means the proponent of the will here was alive.
Yes, at that time.
Yes.
So the matter is still in existence, my lord, it's still alive, my lord. So the court below could have not passed an order, my lord.
Dismiss you.
Yes, somebody dismissed my case, my lord. This is my only grievance before the Honorable Court.
Yes, Mr. Paske.
Yes, your lordship. The order that was referred by my learned friend just now, CRP 32 of 2022,
Yes.
filed by the appellant
Yes.
against Atul Marak. I respectfully submit that at that point of time, Atul Marak he expired on 13/12/2021. Firstly.
That is recorded, my lord.
It's recorded.
It's recorded.
Secondly, Your Lordship, I would like to take Your Lordship to Annexure 11, page 68.
No, it's recorded in this order that, as noted, Sultan has since died.
Yes.
And such inside proceedings that the mediation and all, it has to be looked at afresh, because the mediation, whoever now, if the heirs or if the legal, heirs are fighting over amongst themselves, that means that it's taking a total new complexion, the dispute. That order settlement. Yes.
Because, Your Lordship, the
let's see 65. What 65?
That was executed.
What 65? Let's see.
65 is the mediation report, Your Lordship. Dated 2nd November 2017, Your Lordship.
Page?
Yes, page 65. Yes.
Annexure 11, Your Lordship.
Yes. What does it say?
May I read, Your Lordship?
Yes.
It basically says that before they came to the mediation, as directed by this honorable court, they have already settled the matter by way of a deed of family settlement. So it says the relevant portion is in the next page, Your Lordship. On the first appearance of on the third paragraph, Your Lordship, upon meeting the parties as indicated above, it is seen that basically the main dispute between the parties is regard to some landed properties which the matter was.
Where are you reading from?
Before the various judicial
Page 69. He's reading from page 69, my lord.
Page 69, Your Lordship.
Yes.
Third last paragraph, Your Lordship.
Yes.
Upon meeting the parties as indicated above, Your Lordship, has it?
Yes. Yes.
It is seen that basically the main dispute between the parties is regard to some landed properties for which the matter was agitated before the various judicial forums and finally before the Honorable High Court, and as expressed by the parties themselves, the dispute has been resolved at their own level, for which the mediator is only to guide the same for final.
But this is 17. Mr. Pasquet is 17. This order
2017, Your Lordship.
Right. And then after, what happened after that? After they had come to the court because he didn't adhere to the terms of mediation. That is why. And he died.
Yes.
He did not
comply with. Yes.
Because it's not Lok Adalat order. It's because mediation is
Your
not.
Lordship, by the time when the will was executed, Your Lordship, the matters were the matter stood agitated and it was mutually settled between the parties.
But he was never a party there, my lord. He was never a party in the settlement also.
Even in the deed, Your Lordship.
Who was never a party?
The respondent was never a party. Yes, he was never a party there in the settlement.
I was a signatory, Your Lordship, in the deed of family settlement. I was a signatory, so that means I was a party to it. I am the witness number 1, Your Lordship, page 74.
Where's the deed of family settlement?
Page 76 is the deed of settlement of family dispute, Your Lordship.
This will is made by? No. This is
page 70, Babu. Page 70. 11 years.
70, Your Lordship.
Page 70.
Page 70. Is the deed of settlement. Your Lordship,
between the appellants and the deceased.
9 plots of land, Your Lordship, in various parts of Tura town. Your Lordship, this schedule 1 on the next.
So you mean to say
Lordship,
that this your client succeeds Atul Marak?
No.
Yes.
Yes, succeeds.
So the thing is that now, this moment, these properties which by the settlement they fall within the share of this one who died, Atul Marak. That means they are in possession of the respondent now.
Not they. I'm still in possession.
Then?
I am in possession, Your Lordship, of 1, 2 and 3. Schedule 1, 2 and 3 rests from 3 to 9. 6 properties are in possession of the appellants herein.
Even though settlement should have been with the Atul Marak. Now it's very confusing.
My submission is, Manok, this settlement has not attained finality because they did not comply with the settlement, the order passed by the
So you have not complied yourself also?
So that is why we approached this honourable court, my lord.
You have not complied with settlement also. If you're holding on to properties, you should not be within your share. Correct?
No, I was all along in that property, my lord.
See, if Schedule 1...
No, even lordship goes to the merit of the case. I was already holding patta, my lord, of those some of the properties.
Okay, Schedule 1 is with whom? With you? Mr. Paske?
Schedule 1 is with me, Schedule 2 is with me, Schedule 3 is with me, Schedule 2 is my place of residence.
Then that's fine.
I'm residing.
That means you don't have claim to 1, 2 and 3.
And the other rest of the city's properties are with the appellant's hearing.
Yes, so?
Your Lordship, and the last covenant at page 74, Your Lordship.
Yeah, Bina Roy, right?
Yeah, Bina Roy.
Then see, as per the settlement, you will have...
Your Lordship.
Atul Marak will have 1, 2 and 3. Now, you are having 4, 5, 6 and 7. So you have 4, 5, 6.
No, but how can he claim?
8, 9, yes.
8 and 9, 6.
Now that probate case also, my lord, was passed behind the back of...
No, he asked for probate of his father's properties, correct?
Yes, he's asking.
Then you've got a property. If it was to go to you, you would have gotten the deed.
No, but the last order says that we're still in dispute, my lord.
Everything.
That is the claim, my lord.
You want everything?
Yes. No, because the probate order, my lord, was passed behind the back of the appellants, my lord.
Fine, that'd be all right. But I think if, as per the settlement, some property that should have gone to you was willed by the testator or whatever, and he has got profit for it, then maybe you have something is amiss. But if, as per the settlement, this Atul Marak has died now, so 1, 2 and 3 is gone to...
He has willed it to his son.
And he has willed it to his son, then...
No, but that is still in dispute, my lord. That has to be adjudicated.
Where the will?
Your Lordship, the will is at will is at page 23.
Page 23, my lord.
23, Your Lordship.
Yes. Where's the order granting probate? Was they examined the witnesses?
No, the witnesses was not examined, my lord. Only 1, 2 witnesses. These witnesses was examined. I was never issued a notice, my lord. Only after the demise, my lord, when they were still in bereavement, my lord. They have obtained this.
It was whose custody this will?
Your Lordship,
it was in his custody. We were never aware about this will also, my lord.
Why should he be aware? You already separated from him, and then he's given you 9 properties. He's kept 3.
His daughter, he was remaining with the daughter, my lord.
His will is see to his son. So
the son came out from nowhere. He was already there in Delhi. After the father expired, now he comes and tries to claim over the property, my lord.
Doesn't matter. Might be in America also.
Yes.
Doesn't mean father can't will to his son. As if
he was looking after the father, Your Lordship.
The lion's share.
No, that is a disputed matter, my lord, because the funeral expenses was borne by the wife.
That's of no consequence.
They didn't even participate in the funeral, Your Lordship. I have clear instructions from my client.
Where's the order of probate?
It's at page 65, my lord.
Granting probate. Where's that?
Oh, granting probate.
Now we look at that.
Page 34, my lord. That is the type copy. Page 34.
So we understand now, Mr. Movin. It's not that this person's asking for a share fallen into. You ask, you did settlement, you got these 9 properties, they're with you. With some, he will that.
Even the patta also, the one which is claiming, my lord, is still in the name of the.
When the matter came up for court first time, Mr. Paske, it was not argued properly. Because what was this court given?
Yes,
that the deed settlement had been entered into and was being flouted. And that's why the person had died, so the settlement has lost its force. But you look at the settlement now, and if he responds claiming the property given by his father, yes.
Then even since it's also the legal American can also claim, because as per Garo customary law, the property belongs to the daughter, my lord. And the son has no right over the property. Lordship goes to that customary law also. The son has no entitlement and whatsoever.
Yeah, now the thing is like this. The thing is that your sister is not claiming anything.
Yeah, claiming. She's claiming, my lord.
Contesting
yes, she's contesting. She's before this honorable court, my lord. She's the appellant here.
She's with the mother.
Yes, she's with the mother.
He was the party in the settlement deed as well, Your Lordship.
Okay, we'll put her up for mediation again. Come. Yes.
I think it will not suffice, my lord, the mediation.
It will. You will understand that he already taken lion's share. So, like whether this, notwithstanding this probate,
he was some of the property was already distributed to the son, my lord. Now he's again coming on the basis of this probate.
Not some, only this.
Some, my lord. No, always coming, my lord.
His only son.
No, another son is also that they are again fighting over other properties, my lord. The son, they file a title suit also, my lord.
Yes. Okay.
My main grievance is that, my lord, the order itself is illegal, my lord. The witnesses were never examined, issues were never framed, hearing was not even done. On the basis of res judicata, passes an order, my lord. How can that be issued, my lord? And when there is a specific order by this honorable court to dispose of the misapplication, direct disregard to this honorable court's order, my lord, and went through the merits of the case.
Then
it's not. It is registered the will.
Form or nature of
Only
proceedings, Your
notarized.
Lordship.
It was not registered, my lord. And the signature also disputed, my
Does
lord.
not need to be registered also.
The signature is disputed. In some of the signatures, it's not signed like that, my lord.
Your Lordship, who are they to challenge it, Your Lordship? When it was.
We are the legal heirs, we have every right to challenge it. Even you also don't have right to challenge it, if that be the case.
One second. Don't get too excited. Where's the settlement again? Where's the settlement?
Settlement, my lord.
With the probate petition.
Probate petition has a page.
No, I got provisions at page 19.
Yes.
Where's that settlement?
Page 70, my lord. Page deed of settlement. Page. Where? Page 70, my lord.
See, okay, schedule 1. It is the same property. Schedule 1, the Damong Damjong Gray 364. Right. B is PP 708. Yes, same. 3. Same. So this, see, application probate is also is identical to the property that fell in his father's share for the settlement. So as per the settlement, you're out.
No, but that settlement failed, my lord. That is mine.
It didn't fail.
No, it's failed, my lord.
You're holding the property is correct. If you're not in possession of the property settled with you, we can say it failed. But the father at the time of his death, when he willed it, he was in possession of these properties, and you had 1, 2, 3, 4, 5, 7, or 6 properties. So the settlement didn't fail.
No, it failed. That is why we before this honorable court. That is why the judgment is there, my lord.
Judgment is there because of the correct facts was not brought on board that way. That's why.
No, it's clearly mentioned here, my lord, in the paragraph 3 that mediation failed. The settlement failed here, mediation agreement. This is the order passed by this honorable court, my lord.
You can't if Mr. Moomin didn't come to the court with clean hands in the first place with that settlement, you can't put it to the court now. We have enough power to review own judgments also.
But that is true, my lord.
Yes, we'll file, accordingly we'll take down, yes, this first appeal. Why first appeal? It's against the Mrs. matter, right? Yes, is directed again. Order dated. Order dated
2/7/2025, Your Lordship. 2nd of June 2025.
7/2/2025 in revocation of probate case number 1 or 2023. Part of the learned judges council called Torah. Stop. The appellant herein is being aggrieved with the grant of probate. What's the application for revocation?
Page 49, my lord.
Being agreed with the ground of probate in favor of the respondent. Which they allege was on the basis of a fraudulent document, had approached the court of the district judge, which had granted the probate in 13/5/2022 for revocation of the same. Stop. The petitioner or the applicant is submitted. The applicant submitted, the applicants who are the appellants before this court submitted are the wife and daughter of the deceased. And no notice was given to you.
No, not to
At
judges.
the time of grant of probate. Where's the order granting probate?
Page 34 is the type copy, my lord.
Page 34. Of grant of probate.
Page
Page 33.
32. 32, my lord.
33. Time of grant of probate. Before grant of probate, the appellants were not put to notice, though they are vitally interested. He further submits that the matter then travelled to this court by way of CRP number. What is the first order?
Page 62, my lord.
By way of no, the first order where it was said that this court he said that is with the first
For
order.
misapplication, my lord. For disposal of the misapplication.
No, this other one regarding that finding that the settlement has failed.
Oh.
Page 85, your lordship.
Page 85.
Annexure 14.
Yes. Number 32, 2020. Stop wherein it was submitted that though the mediation agreement had been executed, the then sole respondent, namely Manakul C.H. Marak, the proponent of the will, had not abided by the same, which had compelled the petitioner, appellant herein, to come to this court. From this court, he submitted the order dated 33/2022 and dispose of the matter by allowing the parties to resort to pursuing the remedy before the appropriate forums. So, thereafter, it appears the probate was filed. Thereafter, by way he submits by another CRP number 8/2024. You filed with 23.
Yes, my lord.
This order of this, to get the chronology correct. 1 second.
Yes, 23.
1 second.
For revocation of probate case, my lord.
No, just 1 second. Just give me 1 second. I didn't do this. It was passed on. 3/3/22. Then the Miss case you filed in?
This case 4th April 2023, my lord.
23. And when was the probate filed?
It was filed.
Thereafter, we approached this honorable court, my lord.
The probate was filed by, when was it filed, Mr.
Probate.
Yes, Your Lordship. Probate was filed
17 March 22, my lord. 17 March 22.
It's 21st March.
24, 3, okay. 24.
21st March 2022.
What is the order of probate?
No, that application was filed on 17 March.
March, you sure?
But here again, the verification is differing, my lord. It's 21st March of 22.
March 2022, Your Lordship.
21st.
21st March.
Page 21.
21st March 2022.
21, yes.
2022, Your Lordship. 2.
No, no.
Page 21, Your Lordship.
21, my lord. Verification is mentioned 21st March. Page 21.
Yes, 17th March 22.
That is the affidavit again, my lord. Verification is again different.
Where's the verification?
Page 21.
Verification is at page 21, Your Lordship. Prior to that, the affidavit was got notarized, but it was filed on the 21st of March.
You have no legal impediment. Where's the verification?
It's page 21, my lord.
Page 21, Your Lordship.
All the pages have been, been scored over, and verification 21st day of March. '22. And then you file affidavit later on. Affidavit was before.
It was before.
How is it possible? If affidavit was on 17th March,
yes.
Verification is on
21st March.
21st
Because, Your
March.
Lordship, I had inquired, Your Lordship, because 2-3 days the courts were closed. The filing, when the date it was filed, they had written 21st, because 21st it was filed. 17 it was notarized, the affidavit got notarized.
Okay. Very confusing, the dates, yes. That's all right then. 2020, no problem. Okay, stop there. Stop. I thought somebody we just record this. After that, Mr. AG movement submits that. Thereafter, in the ensuing period, the respondent on the demise of the then sole respondent, Sri Atul Marak, had filed for probate of a will dated. Deal dated. Damn, sorry.
13/12/2021, Your Lordship.
30?
Page 23. 13th of December 2021.
I think do one thing.
Page 23, Your Lordship.
Just give me a list of dates. Give me a list of dates. We'll have it day after tomorrow. But give you see this. It's too confusing for me to note down. Just list of dates. See, number 1 is that order of deed of family settlement. Okay, start from 17 November.
Yes.
November 17, right?
Then after
then from
order.
there, then the first time you came to this court, 2020 CRP.
Yes.
Then after that, it happened that then he died in 22,
yes,
when the matter was still pending. Then in the meantime, they had filed for probate. Probate was granted.
Yes.
Then you came for this court again.
No. We went to that court. Yes.
We went to that court. You filed an application. There is application for keeping the probate in abeyance, right? For revocation. Rather, revocation, yeah, for revocation of probate. Then that was not settled, that was not disposed of. Then you came to this court by 22 CRP. Then this court said dispose of the miss case first.
No, my lord.
Yes.
No, we came to court, my lord, only after miss application was not disposed of.
Exactly.
Yes.
See, it goes like this. First is settlement on.
Yes, it was first was settlement, my lord.
17,
yes.
Right? 17. Then everything was quiet.
Yes.
Then you came to court
because the mediation failed. Yes.
It
then after
didn't
that.
fail. 2020 you came to court saying that he's not abiding by the settlement.
Yes.
Suppose not going merits, you pursue on remedies.
Yes.
Right? Because
Yes.
that's your submission.
Yes, yes.
Is that recorded of court?
Yes, yes.
Your submission that he was not abiding by the
Yes.
settlement. So then he said, okay, we'll go on remedies. So meanwhile, what happened? On remedies means they filed for probate.
They filed for probate.
They have probate, they obtained a probate, then you file for revocation of the probate.
Yes.
Then revocation of probate, then you file a miss case for revocation, that's not taken up, whatever. Then,
Came to High
you
Court.
came to court again by
Yes.
22, then CRP.
Yes.
Then the court says settle off that
Misapplication.
misapplication, then that was settled, and then you've come again. Only thing we need the dates when it applied for probate, when it was granted, when is the application of probate filed, when was the probate granted, when did they file revocation, and correlate with the dates that they come before this court. Start from the mediation proceeding first. Otherwise, forever will be swimming in dates.
Okay, Lord.
Matter is very simple, but yes.
Lordship. We'll do that, Lord.
Friday after tomorrow.
Lordship.
Yes.
Meanwhile, status quo, my lord, maybe maintained.
That is what you're holding the property, you're holding the property. It's fine. Should be happy.
Lordship.
He's not interfering with your properties.
He's interfering, my lord, that is why.
Okay.
He's interfering, that is why.
So your mother and son. Yes. Yes.
Lord.
Very
Deeply obliged, Your Lordship.
Dates.
That's how it unfolds. Because the first round just.
It's just getting used to all the dates, Lordship.
Yes.
Yes, my lordship. Petitioner is the first wife only, which is legally married by the late Peterson Sangma, and that Christina C.H. Marak, she is just an affair before married. But in the pension book, it's written her name as Christina C.H. Marak as a spouse. So the legal wife, she is claiming for pension.
Who cancelled this by yourself?
No, it's done by the Witterson only.
It was by the deceased, Lordship.
Yeah,
he got angry, went to the office and cancelled it and took out the photograph. I have it in my affidavit of the respondent number 4.
Okay. Got angry with you. Or the second wife?
With the first wife, Lordship.
No. First, Nalini is only a first wife because Christina isn't just an affair before marriage. She never married to a late Witterson.
Okay, who has the marriage certificate?
Nalini petitioner. Yeah.
Let her place a case. So, Nalini, Baba, okay. So who's getting the final pension now? Who's getting the final pension now?
After the deceased, Your Lordship, it's just the deceased who got it. Now the second wife is claiming it.
So there's a contested claim, essentially, Lordship.
And then I have to go for evidence. Yes, let's see affidavit. Only on behalf of the Treasury officer you filed.
Please, Lordship, because Treasury officer is competent to narrate all the facts that are relevant here. In fact, Lordship, if I may take you to the annexure.
Yes, please. Your annexure.
My annexure.
Yeah, this is the.
Sorry, my Lordship. So if your Lordship looks at the PPO, which is at page 6.
Yeah.
That is a PPO copy in our Treasury office. Without the scratchings.
Christina Marak, okay. Wife. Okay. Why you didn't make her respondent?
Because Nalini, she never met the Christina after dying. Her
Whatever
husband
it
also,
is,
yes.
that's the thing. But then if her name is reflected there, then she should be to answer before the court also.
Yes,
We'll
yes.
allow you to implead if you want.
Please, Lordship. Because
then that implead, then if she might not contest it also, you don't know.
Yes.
Very true, because as per our records also, which is available in our
She's
office,
not come
Lordship,
forward.
she's not.
Christina's
she's
never
not-
come
The
forward.
first wife's name is there.
Lordship, if I may, she has approached the Treasury office. In fact, in my affidavit, she had approached the Treasury office. The petitioner also had approached the Treasury office, and they were both advised to enter into a settlement deed,
Yes.
which they have not been able to.
You know where she stays?
Huh?
You know where she stays? Miss Christina, you know where she stays?
I don't know.
Because you can't have it one way, and we can't. You have to be heard. Can you get her address?
Huh?
Can you get her address?
No, she also don't have any idea about that. Even the
Lordship, I can take instructions from the Treasury office if they have it.
Yes. The instant matter appears to be in the instant matter, it appears that the administrative party, namely
Christina CH
Marak,
who stated to also be a wife of the deceased employee and whose name appears in the service report, has not been made party before this court. Stop. The claim, the next matter, the claim of the petitioner basically is that she is the first wife.
first wife means she never married to Peterson.
She's got the.
But even then, if it's proven that you have some relationship with him, your children will get something at least. That's
The name in the kindred roll is also reflected. Her name is reflected. Even the children's name reflected.
Oh no. Okay, so clear petitioner is for the family pension of the deceased employee on the ground that she's also a wife, out of which wedlock. How many children were born?
I don't know.
You know how many children you have?
Oh, Nalini. Oh, yes, she had two.
2 years
Yeah.
children. Stop. In the concerned view of the court, the matter cannot proceed further without the necessary party being brought on record and arrayed as a necessary respondent. Stop. On a query from the court, what's your name?
Hiramakhanda.
MS so and so, or the petitioner submits that they are not aware of the address and whereabouts of the thank to Christina, whatever. Stop. Mr. ESD Al Jangsha has volunteered to try to obtain the same from Treasury office. Just after 2 weeks, yes, for the orders in the order column.
Thank you, Lordship.
Otherwise, see, we give you indulgence because you never appeared in this court, so you're trying to argue the matter yourself, which is very good. But at least try to get the address also.
Okay.
Then we can resolve it, because at least your children will be entitled to something, and if you send it, we'll send it for mediation also. Then I'll explain, even if you're not recorded legally wedded, why, but if the children are born from that wedlock,
yes,
so you can share it with the name Christina.
Yes.
Right.
Okay.
Yes.
Thank you.
Obliged.